Mic check. Mic test. 1, 2. Pleasant morning, everyone, and welcome to the public presentation on Jamaica's alternative justice systems. I'm Roger Bent, and I'm going to be your moderator for the better part of this presentation today. And this particular event is a closing ceremony of what you will find out throughout the course of presentations to have been 24 months of hard work. And so clearly a lot of intense work would have gone through, and during the course of the next 2 days it will unfold just the extent and all those different areas that would have gone into. So certainly a whole lot of interesting tidbits to be gleaned in the next couple of days. We also take the time out to acknowledge our partners, our key partners, the University of the West Indies, members of the European Union, even though a part of the University of the West Indies, the Department of Government, an integral player as well as Institute of Caribbean Studies, and also the ERJ, Equal Rights and Justice for All. So a number of actors so far would have contributed, and you will hear from a number of panelists throughout the course of the day. And those will update you as the day go by. In the next couple of minutes, you will hear in an overview presentation from Dr. Shanique Walters, and this will then be accompanied. This will then follow a panel presentation at 10:30 to 12:30 p.m. But first, let's give you an overview as to what is this whole idea of Jamaica's alternative justice systems? How did it come about? What's the whole interest in it? And I'm going to be giving you a slight summary of it, and then it's going to segue into the presentation by Dr. Shanique Walters. So the University of the West Indies, Mona, embarked on 24 months of project work with the European Union funds on alternative justice project. The project sought to add to the work of the Ministry of Justice and Restorative Justice Act of 2016 by providing a critical research data promoting the work of the Ministry of Justice and Restorative Justice Centers, and adding to the capacity development of the restorative justice operators across the island. Additionally, by focusing on child rights and the protection in the family and measures aimed at reducing community violence. The UWI sought to enhance the capacity of the alternative justice to expedite and support the larger crime control response, especially those of child services, such as the objectives of this project, such that the objectives of this project should enhance the victimology focus that is intrinsic to the alternative justice systems. Now, the next presentation coming up from Dr. Walters is going to be more intentional, looking at how she built out those technical work packages. So please make her welcome. She will now take you through those phases and then into the next phase of the presentation. Dr. Shanique Walters, make her welcome. The clap is good.
All right, so what I'm going to do, I'm just going to take you through a basic understanding of what we've done from the start of the project. So the project started in 2018, and we engaged a number of partners. And these partners looked at persons like the Jamaica Teachers Association, we had the Child Protection and Family Services Agencies, we had the Planning Institute of Jamaica, and we had the Ministry of Justice. However, the purpose of this was to try and develop an investment. So the investment looked at both the UWI and the EU. And throughout all of this, we have to be grateful because we've realized that we've spent about 51 million Jamaican dollars. In terms of the project objectives, we're trying to develop a community justice framework that incorporates the lived experience of citizens and law enforcement, while we're trying to advance the use of ADR with a focus on gender-based violence. Now, the project was driven by 6 main elements. The first one was a legislative review. We had the baseline studies. We looked at the restorative justice centers. We had a capacity and needs assessment and quality assurance. And I'm just going to try and explain each of these as we continue. So the legislative review. So the project was actually conducted several reviews, all related to alternative dispute resolution, and made recommendations to both political parties leading up to the 2020 general elections. With the baseline study, we encouraged, or we looked at a nationwide assessment of the users and non-users of the alternative justice system and legal aid, with the aim of making the services more responsive to the population. With the review of the Justice Center, we had the partnership with the Ministry of Justice. The project carried out the operational review of 5 justice centers across the island. In addition to this, we also had an additional baseline that identified the primary sources that public turned to for information related to justice after the project conducted an assessment of these sources. And as a quality assurance, one of the things that we wanted to ensure was the whole issue of sustainability. And that we did by developing an online community. And you'll hear more about that as we proceed. Now, there were several major milestones for the project. The first one was a framework that was developed together with the restorative justice and peace centers. And the whole approach was to try and develop the modules that processes working around it, and by so doing, the models facilitated greater buy-in and ownership. We also tried to develop a framework which included a community mapping. Each community had its own distinct features, institutions, relations, so we tried to understand the culture that existed, and we tried to create an ADR also around that. In addition to this, we had the RJ referral processes that show the restorative justice centers at the base of the model. So this was done to try and create a systems of referrals. And this was done by beginning with the consideration of the justice center, as the proposed framework allowed for the center managers and the community to have a more central role in how ADR is executed without changing the system. The final thing that we tried to look at was that each center should be more equipped with the capacity to engage the communities and its stakeholders. And this was done to try and develop a framework for interacting with the various agencies to ensure that RJ and alternative dispute resolution was an option. So we looked at the major milestones, however, we found some capacity. And I'm just going to touch on some of them. You'll be introduced to a lot more as the presentation continues. You'll hear a lot from Dr. Burke in terms of what she's done in terms of child's right. But some things that I think that we can bear in mind. So, for example, only 12.74% of the respondents were able to sufficiently define what is child rights. And that's something that we took on, and we tried to create Instagram profiles around that in terms of helping us to address it. In addition to this, a little over half, which is 55.6% of the participants, were unaware of, only somewhat aware of, how the identity a child is needed of care and protection. This exposes the possibility of serious underreporting, since only 25.5% of the sampled educators were aware of what classes a child being in needed in terms of care and protection. Additionally, we had 1/3 of educators demonstrating partial understanding of the best interests of the child, principles, and a lack of understanding child's right to participants as a part of the best interests of the child. 44.8% also responded that identified that the CDA as the reporting agency, even though this entity was merged under the Child Protection and Family Services Agency years before. And approximately 5% of the respondents self-identified as not reporting suspicions of child abuse or a child in need of care and protection. So as you can see, a lot of things came out, and as we're trying to address them, we're trying to address them from a policy standpoint, but we're also trying to be as interactive in our approach. Now, in terms of the Jamaicans reached throughout the project, You had building resilience within the family. So we had 10 families receiving mediation and capacity building after engaging violent altercations with the police, family, and members of the neighborhood. We had persons trying to strengthen the use of ADR in school. And we did this based on the baseline that we had. So we had about 143 childcare justice duty bearers, educators, and staff from Ministry of Education. In addition to this, we ensured that we brought in women and the elderly, and that was a part of our vulnerable group. Oftentimes we speak about women, children, disabled persons, but we decided it's important that we also look at the elderly within the community. So in response to this, we had family violence meted out against the elderly and women to the project, and it provided mediation and rights awareness training to about 50 individuals who were over the age of 50, and to 160 women who came in contact with the law due to prostitution and gender-based violence. In addition to this, we also wanted to encourage her to find out what were some of the issues with men. And what we did, we had 50 male non-state justice actors from volatile communities trained in non-violent responses to perceived threats or provocation. We also tried to foster the next generation of non-violent Jamaicans. So we had 230 young people sensitized in the ADR techniques through direct contact and training. Based on the ADR program, we had several awareness among the general population. So we had 500 plus community members in attendance at public fora, and we had 500,000 Jamaicans that were sensitized via our media activities. So based on all of this, we wanted to understand. So we had 500,000 persons, and we needed to understand what was the profile in terms of the trainings for these people. So one, we had 47% who were never trained in child rights awareness, and we had 49% who were trained in GB rights, gender-based violence right awareness. From a regional diaspora perspective, we had 20% of these participants in training sessions were non-Jamaicans living outside the country at the time of the training. I think that's something that we must commend. We had 30% males and we had 70% females. In terms of we tried to understand the characteristics around these persons. So we found that we had 17% of the legal fraternity, we had 21% who were government of Jamaica workers, and we had 44% who've never received ADR training. So based on all of this, I'm trying to understand, and we're all trying as a team to understand what were the activities of the EU Justice Initiative. So we started off by trying to identify some things. So the first thing, that based on what we've identified, we've shared that with all political parties that look at ADR findings resulting in ADR reform as being a part of a featured strategy in the manifestos of both political parties. We try to also be innovative, so we facilitated the development of alternative dispute resolution, women's drama group developed in both Flesher's Land, Arnett Gardens, Rosetown, Trenchtown, and Denham Towns are just a few of the communities that we looked at. And we try to look at the whole management of it. So we try to establish the Jamaican Association of Mediators, and as I said, tomorrow you'll get a better understanding of that as we launch the online portal. And we're trying to understand how in terms they're stimulated to develop the best practices and standards operating procedures to strengthen professionalism within the sector. Throughout all of this, we're trying to figure out now, how can we improve? So we've started out by 3 P scores that has been developed in 2 parishes, and is focused on counseling and the provision of safe spaces for family development. Long term, and it's important because again we understand in terms of the outputs and the activities, but long term, what's some of the impacts that we can achieve? So we started off again by also trying to identify, and we also looked at the elderlies, as they're often overlooked when we're discussing the issues of justice, and there are several reasons behind that. So that's something that we took on, and we also tried to improve the justice initiative by influencing the statin and M&S to include restorative justice indicators on the National Victimization Study. Looking at the whole management of it, so we've engaged the Women's Foundation of Jamaica. And one thing I should have mentioned earlier is that we also developed several grants. So we offered several grants, which was guided by the PIOJ. And one element of it looked at the whole issue of offer an annual ADR and family service to teenage mothers facing abuse. And we also engage the Manchester Parish Development Council, who's equipped with the resources to offer ADR and right awareness to 4,000 homes in Jamaica. Throughout this activity, yes, we were affected by COVID-19, and we met as a team and decided, okay, how can we address this? And there are two things that we tried to focus on. So we realized that education was not at home, and we realized that there was an issue in terms of care packages, especially when we look at the vulnerable groups. So we tried to provide 8 schools, 2 urban and 6 rural, with the ICT equipment needed to host class virtually. We tried to develop ADR and rights awareness animated videos, and the videos from the students were so good. It's actually on our Instagram page if you want to see. So the students did very fabulous videos, and we tried to award the school for the work that they actually had produced. We've also provided school catering for students living with disabilities with ICT equipment. In terms of the care packages or the meals, we tried to offer 400 individuals who are facing abuse due to total loss of reduction in income, and we try to look at all persons who are provided with contact information on the nearest ADR centers. So with this, we have to say a big thank you to the European Union for actually, entrusting us with this project activity. And this is an activity, a lot of things have come out, but through it, there's still more things that we need to do. But at the end of it, we just have to say thank you to the European Union, and I think that's it. Mr. Bent?
Thank you, Doc. Thank you, Dr. Walters. So from her presentation, you would have heard her broken down the different work packages that she had. One of the first that she spoke to would have been this whole idea of consolidating a strategic legal framework, a kind of a space for restorative justice, mediation, and legal aid access. She also looked on this whole idea of providing a space for alternative justice actors to meet and to share best practices. And she also looked on this whole idea of a robust behavioral change awareness, right? That would have informed how citizens and social actors and partners would have been able to be aware of rights and adequate justice. So quite an in-depth presentation that showed over the last 24 months just how much was done and all the different areas that were touched in the process. Just to give you a sort of idea in terms of, even if it is already stipulated, but the next presentation is presentation on the state of Jamaica's alternative justice network from the perspective of users and non-users. This presentation is a baseline findings by Dr. Gavin Daly. It's a panel discussion, and on that panel is going to be Miss Claire Miller. She's a trained mediator, Mr. Isaac Buchanan, attorney at law, and of course Dr. Gavin Daly. So please make that, welcome the presenters at this time. Presenters, please take your space at on the podium. So again, the presenters are Dr. Gavin Daly, Miss Claire Miller, and Mr. Isaac Buchanan.
Okay, good morning, ladies and gentlemen. It is indeed a privilege to be here today to present key findings on a baseline study that was conducted by the Center for Leadership and Governance about perceptions and use of Jamaica's alternative justice and legal aid services. At this point, I would like to acknowledge the CLG team, which is spearheaded by the Department of Government, who was instrumental in assisting in data collection, data entry, and analysis where the study is concerned. Special recognition also to the steering committee of the wider project, as well as the Ministry of Justice, who coordinated as well as assisted in the construction of the questionnaire for the project itself. And last but certainly not least, the European Union, represented by the European Commission, for commissioning such a project that is timely and relevant, especially for jurisdictions whose justice system is perceived as inefficient. In terms of the outline for my presentation, I will begin with an introduction which will set the context for what is to come, followed by the methodology which guided the study, and finally some key findings. So, to begin with, in an IDB series report on crime and violence in Jamaica, where our two principal researchers, Professor Anthony Harriott and Marilyn Jones, noted that since in 2016 there was a spike in the murder rate, and this has attributed to a very high, Jamaica having a very high homicide rate. In fact, recent data has shown that we have jumped probably a space or two. Currently 57 per 100 people. So we are pretty much behind countries such as El Salvador and Belize. It is argued that the country's traditional deterrence mechanism have been rendered ineffective against the increased rates of criminal activity. And this is evidenced by police frequently being unable to make arrests, and coupled with the fact that courts only convict about 7% of homicide cases. In a report generated by the Crime and Safety Unit, the public as well as the police have doubts about the effectiveness of criminal justice system, which often leads to acts of vigilantism, which exacerbates the cycle of violence. In a press conference, the former police commissioner, George Quayle, expressed concern over the slow justice, stating that police were not to be blamed for the escalating murder rate. In fact, he went as far as to say that he had concerns about the witness tampering that can occur, which is usually as a result of court delays. The National Crime Victimization Survey that was commissioned by the Ministry of National Security also revealed that approximately 15% of citizens believe that the courts are doing a good job helping victims or providing justice quickly. So the remaining 85 are of the opinion that they are not. The IDB report on crime and violence in Jamaica cautioned that citizens' reluctance to serve as jurors, failure of witness to come forward, cases of persons being lost in the system, inadequate indigent representation, and/or delay or dismissal of cases due to loss of destroyed files contribute to this perception. So in seeking to address this issue of crime and violence and having a very inefficient justice system, the government of Jamaica between 2009 and 2014 passed several pieces of legislations, and of course to improve the existing reality of our justice system. So in this context, the Center for Leadership and Governance, on behalf of the wider project, conducted a baseline study to solicit the perceptions of Jamaicans surrounding formal and alternative justice services. So the objectives of the project: 1, to obtain statistically reliable data on the perceptions and levels of awareness of the availability and function of restorative justice and mediation and legal aid service providers; to obtain statistically reliable data on the attitude of stakeholders of alternative dispute resolutions and legal aid services, and to identify the primary barriers to accessibility. 3, to obtain statistically reliable data on the commonly used channels of communication through which ADR and legal aid centers can communicate with its stakeholders. And finally, to establish a baseline to enable the monitoring and evaluation of the impact of ADR and legal aid interventions with greater accuracy. Now we move into the methodology. So in consultation with the steering committee, we employed exclusively a quantitative approach, which saw us using a questionnaire to collect data. Data was collected over a 3-month period between September 2019 and December 2019. We targeted both users and non-users of formal and alternative justice services. In fact, we had a sample size of 1,016 users and non-users. 69% of the sample, which is approximately 698, were users of either mediation, restorative justice, or legal aid services. The remaining 31%, which is approximately 368 thereabout, were non-users of these services. In terms of the profile of respondents that we targeted, approximately 55% of the sample were females and 45% males. 41% completed secondary school, 15% vocational skills training, and 28% completed or is presently pursuing a university degree. In terms of employment status, 42% were employed full-time, 8% said they were out of work, 16% were students. In terms of the age distribution for the sample, we had persons participating in the study from as low as 18 years of age to as high as over 66. All right. Now, to move to the key findings, I would like to first state that when we attempted to ask respondents about their level of awareness of these alternative and formal justice services, we had some challenges. Some respondents were not readily able to identify with what is mediation service, what is restorative justice, and what was legal aid. So one of the instructions to the surveyors is that it is critical that we provide a definition. And now there are several definitions offered across institutions, generations, and disciplines as it relates to what is restorative justice, what is mediation, what is legal aid. But the definition that we used was that which was cited by the Restorative Justice Council. And essentially, they argued that restorative justice is a process that brings together those that are harmed by the crime or the conflict and those people who commit the crime into communication, enabling everyone affected by a particular incident to play a part in the repairing the harm and finding a positive way forward. So that's the definition we used for the study. Mediation, on the other hand, which is also an ADR, is defined as a voluntary, informal, and flexible process of dispute resolution. So it's a form of dispute resolution found outside the adjudicative space of the courtroom or the tribunal, where parties in dispute or conflict utilize the assistance of a third party who is considered neutral to attempt to resolve their dispute. And legal aid, of course, is defined as the provision of assistance to people who are unable to afford legal representation and access to the court system. So those are the definitions that we worked with for the study. Now, respondents were asked the question, have you ever used any of the following alternative and informal justice services? Interestingly, 62% of the sample stated that they are aware. Aware. So the question was, are you aware of the following alternative and formal justice services? And interestingly, 62% said that they're aware of mediation services. 69% said that they're aware of legal aid services. And 33% said that they're aware of restorative justice services. So, to put in perspective, approximately 54% of the sample were aware of these formal and alternative justice services. The reasons cited for why do respondents prefer ADR services to formal court, there were several reasons. One, they said that it was very complex. In fact, I had the opportunity or the liberty or the freedom to interview a respondent, and one of the things they shared with me was that it was toxic even to get a parking. Very toxic, because these courts they don't provide public parking. So that enough itself. And then the lengthy delays, court begins at 9 or 10 depending on the court. It's costly, less responsive to the needs of victims, and of course the overall disappointment with the informal justice system. Good. Then we asked respondents how much confidence, how much social capital, if any, do they have in ADR and legal aid services. And interestingly, even though mediation came out as the service that is more common among users and non-users, there was more confidence in legal aid services among the group that was targeted. So if you look carefully at the chart, it is basically saying that over 50% of the respondents express confidence in legal aid, which further contribute to waning public confidence and alienation from the justice system. For mediation, the public high confidence in mediation reflects the justice system's effectiveness in creating community capital to increase public confidence in the criminal justice system and other agencies with a responsibility for delivering a responsive to antisocial behavior. And almost 1 in every 5 respondents, which is approximately 38% of the sample, were confident in restorative justice. So it is important to note that about 23.5% of interviewees were unsure of their confidence. So this is quite interesting. Now, interestingly, when respondents were asked their access points to gathering information about the different services, ADR and legal aid, it was revealed that justice sector personnel were the least accessed source for information surrounding ADR and legal services. So JP's court officials, lawyers, and the police were the least used to access information on alternative justice and legal aid services when compared to primary agents of socialization. So users of both users and non-users of ADR and legal services would often cite or state that their access for information on these services would come from the family, would come from friends, or would come from the school or the workplace. To ensure the accuracy of the information received, one of the recommendations from the study is that the dissemination of information ought to come from state institutions, ministries, departments, and agencies, because these are specialists in the area, and so it will also prevent any misinformation about what these services are about. How satisfied were you with the respective ADR sessions? So this was one of the questions we posed to researchers. And right, 30% stated that they were very satisfied with the actual session. This is for restorative justice, as opposed to 37% who stated that they were very satisfied for during their mediation sessions. 24% says that the process of the session poorly or not was poorly done, or not, it was not explained to them prior to the starting of the actual session, when compared to 14% for those who utilized mediation services. 25% stated that the restorative justice sessions were poor, so no explanation of the option before starting the session, when compared to 18% of those who accessed mediation services. In terms of how users of mediation felt, 23% felt pressured during the sessions, right? So 23% felt pressured, as opposed to 32% of users who felt pressured during restorative justice sessions. And one of the things that we discovered in the study as well is that it took an average of 16 to 36 days after the initial dispute for restorative justice sessions to begin. The question was posed to respondents: what are the types of disputes that can be resolved through mediation? And a large percentage of respondents, 74% to be exact, stated that mediation empowers the community by resolving conflicts and disputes before they escalate into crime. 1 in every 10 participants thought that mediation can have no benefit to them. So even though the number seems low, there is still some work to be done in terms of public education, the importance of these services, and how beneficial they can be. So on average, 27% of respondents stated that serious crimes such as murder may be resolved through mediation. So what is this basically saying? It is saying that the mediation process can serve to humanize the criminal justice experience for both the victim and the offender, where offenders are held accountable to the people they have victimized, and victims are allowed to be more actively involved in the justice process. So the research shows that Jamaicans possess the foundations of inner resources that, under the right circumstances, can be accessed and used to address issues and resolve problems of importance to them. In terms of legal aid, respondents were asked prior to engaging in this particular service, was the process of legal aid explained to them? 32% of the respondents stated that the process of legal aid was poorly or not explained before the start of the sessions. They were then asked to what extent are legal aid services seen as effective, and 57% of users of legal aid services stated that they found the service very effective. Would you use legal aid to settle a dispute where you are the victim or offender? 23% of the public stated that they would seek the services of the legal aid when in need of legal assistance, whether it be as a victim or as an offender. And finally, as it relates to legal aid, respondents were asked if they thought, so do you think that legal aid lawyers are more loyal to state agencies than to legal aid clients? And this, for me, was a very interesting question. And the data itself as well. It says 64% of the respondents stated that they believed that legal aid lawyers are more loyal to state agencies than to their clients. And finally, just to say that in our analysis of the data, we attempted to generate inferential procedures that will determine if there is any, statistical nexus or difference with issues relating to knowledge, attitude, behavior, and practice when it comes down to respondent socioeconomic and demographic orientation. And there were no significance that we found among these cases. So this is pretty much the key findings of the study. Thank you very much.
Into the panel discussion, of course, in which he's a part, and also we brought on two other members that we've identified earlier. We're going to ask those persons to, starting with, well, at least from my right, and then moving on in that order. We're going to ask those persons to introduce themselves, even though we introduced them before, but want to introduce themselves and to tell us about their own work in ADR.
Okay, so start with me. Good morning. I am Isaac Buchanan. I'm an attorney. I'm also a restorative justice facilitator. So in terms of my work with ADR, I would say that this is ironic and probably controversial, is that I actually prefer ADR to the rigid criminal justice system. The work that I do, there are two things that I realize: that poverty is seriously related or closely related or overlaps with crime, as well as access to justice. The quality of justice, certainly in the criminal justice system, is going to be completely dependent on your ability to access resources or have funding to have proper representation. The reality is that the criminal justice system is overwhelmed. It is clogged, and we've moved from a small island person, everybody know everybody type of system, to persons are just numbers. And what happens is when you start to follow countries similar to the United States, where it's so much numbers based, where you are a number and what comes with it is the stigmas that attach to it. If you're so for example, Afro-American, you're a thug, you're all the stereotypes that comes with it. We are sadly adopting that, so that our constitution, which would have stated that you are innocent until proven guilty, that has simply whittled away. So mediation, restorative justice, and the other types of alternative dispute resolution mechanisms brings back the humanness, as well as the victim empowerment, community empowerment, back into resolving conflict. And that's pretty much what I do.
Hi, good morning again, everybody. My name is Claire Miller, and let me first start by just thanking and complimenting Dr. Daly on the work done by you and your team, because it can only help us and all the stakeholders involved in seeing exactly how the public views this system that I would add I'm so passionate about. So I'm an attorney at law and I am a mediator. I was introduced to mediation when I was studying at law school, where we had a little course done, and I liked it then, and I grew to like it even more, because when I started practicing in the courts, and I realized, my goodness, there's really not so much justice there. It's really about who can present the best case, who the parties are, how they can give evidence. And so as a result of that, it never did satisfy my soul to just be in court within a case. So too much was dependent on individuals, and individuals who are perhaps not necessarily interested in the matter that is there. So for me, that was my love and introduction to mediation. So as I said, I practice as a Supreme Court mediator, and so I get a lot of referrals through the Dispute Resolution Foundation, which was actually founded in 1994. So we get referrals through the courts, both the lower courts and the upper courts. Of course, I also get a lot of referrals from attorneys, and I get a lot of referrals from just individuals, communities, everybody. Anybody who knows about mediation, thankfully, I do get to be a part of that process. So for me, mediation, I don't know as much as I said about the restorative justice. I know what it stands for, but for me, mediation, as far as I'm concerned, should start in schools. We used to have a thing called PALS, Peace and Love in Schools, and I think that's really and truly where it should start. And the reason for that is the more that you go and you sensitize people exactly how to resolve their conflict, I think we will have better people, better communities, a better society. So for me, mediation is just it. I know we're going to have a discussion about this comment then, about the findings that Dr. Daly has shared with us. But as I said, for me, mediation is just the way to go. Any ADR process, but for me, as I said, I'm a lover of mediation.
Excellent. Dr. Daly, you're a researcher, so your interest spans wide.
The persons that would participate in the exercise. So, for example, history has shown that probation officers provide mediation services, and in many instances, they're not qualified.
Correct.
They're not qualified, which is something
You have
that
answered my question.
yeah, which is something that we need to revisit. The- and as the study suggests, that they get the information from family members, from friends, from employers, from guidance counselors, and so forth. So it's certainly something that we need to look at.
Okay, so there's some feedback from online, and there are two questions that are being posed. One, how does restorative justice repair harm? And another follow-up to that, it says, isn't ADR just another way to reward offenders for bad behavior? Wouldn't lengthier prison sentences be more effective than restorative justice?
First
Who wants to
response.
take that?
My first response is, what is your name and where you live? that would be the first response. But if I may, on the restorative justice aspect of it, again, restorative justice is, I don't know if I coined this term, but when I was an attorney when I actually became a restorative justice officer, meaning I'm a restorative justice facilitator, but being an attorney is apples and oranges in terms of the use of restorative justice. Now, the term I'm saying, I'm not sure if I coined it, is VOC, V-O-C, which is the victim, the offender, and the community. Okay. These are the persons and the stakeholders that is involved in what is known as a healing circle. So the person who is the victim is empowered, because it starts with the victim. Does the victim want to confront the offender? If the victim says yes, that's the first step. The next step is, does the offender want to make amends? Do they want to apologize? If the answer is yes, then we have the persons who are also affected, family members, support system, and you come into a healing circle with the facilitators, a community rep, a JP, somebody who is back to the African origin where you had the community chief and the whole circle. What happens in that circle is people oftentimes ventilate issues. you tend to find a lot of it is confidential, but one of the most surprising things is offenders are often victims themselves. These things come out in the healing circle. A lot of the interaction and the conflict, it arises from land matters, car, cattle, crop, things that hadn't, if there were interventions with the JP and the head of the communities, going back to first principles where you respect your elders, where your uncles and your aunt could see a teenager on the road and say, go on to your bed, it's 9 o'clock, you didn't need curfew. These things were important. So restorative justice actually is that type of environment. And both the offender and both the victims, they learn so much, and the word is love. They always, that victim empowerment, because in contrast to the criminal justice system, it's the most intimidating and scary place, even for the victim. Can you imagine an entire criminal case goes on for 2 years, and after 2 years, the victim hears that the person cop a deal and the case is dismissed, and she says, but I didn't get to speak. I didn't get my day in court. The man doesn't know that he affected me, or the woman hurt me and I didn't get to say, you hurt me. And so that is the importance of the restorative justice facility. That's the first thing. I will leave the mediation aspect of it to
I think you answered that restorative justice question. I think you did.
Okay, but I would say that.
Yeah.
Yes,
No, I was about to say, I think he answered the question. As you said, it could easily be said, why not just send him to prison? But the reality is, sending the offender to prison neither helps the offender or the victim or the community. As, again, to just repeat some of what Isaac said, which is, when everybody is involved, the victim gets to say her point. Do you understand what you did to me? Do you understand how you hurt me? Do you understand how this now affects my child or my mother or my family? The offender probably gets also an opportunity to say, this is where I'm coming from. I never mean it, or, you know, you look like my dead grandmother who used to beat me, so that's why I don't like you. Because some of these issues are as simple as that. And then you get the community involved, where they're saying, listen, you all live in our community, and if we start this is how feud and turf and all of those things start. So we want to get involved so that everybody can be a part of that healing process. You go to prison, yes, you come out 10 years later, guess what? The wounds are still there. So, you know, the restorative justice is a part to help that healing process. So that is why we say, yes, how can it help healing? That's how it helps it.
There's clearly a sentiment online on this particular issue. Another question says, isn't it more costly to host restorative justice and mediation sessions rather than locking people up?
And the answer to that is
No.
Let me tell you something.
Emphatic no.
Emphatic
You
no.
will agree with that, but I like these questions.
Could we expound on them?
Yes, I want to say this. And, well, oh boy, I apologize in advance. But let me tell you something. Every time you get yourself in problems, the lawyers benefit. And the lawyers benefit from the unfortunate delays in the court system that is unavoidable. It is so difficult to get parties together, whether it be to ask the officers to transport the offender, whether the victim has a dental appointment, whether somebody, parent, whether the judge has something to do, whether another matter. One judge with 300 cases on his list that day. Yours might not be heard, and it's set for another day. And this goes on, and you have to pay the lawyer. And with restorative justice, certainly, a lot of it is the government actually subsidizes the actual restorative justice, the facilities in terms of the healing circle. With mediation, it is a reasonable fee. You honestly don't need attorneys. It is a space where you, again, the individual, gets to say, you in speaking, you probably realize that what I'm doing is not even worth it. But this thing about locking up people, I can promise you this, nothing comes from the punishment. The reality of our justice system is that there's no rehabilitation within it. There is some self-mechanism in terms of the internal locus of control of the individual, but there's no system in place to rehabilitate the person. And what happens at the end, even in 20 years, is that person comes out and then he or she is bitter and says, I pay my debt to society, me no owe nobody nothing, and the victim doesn't get the apology. And so we have that conflict, and it becomes a generational conflict and a lot of animosity, and that's what mediation and RJ does. It's cheaper in the long run, I promise you that.
And just to add quickly to that, cheaper also not just from the cost associated with paying legal fees, taking time off from your work, not knowing how long these cases are going to go from, but it is so much cheaper and more rewarding because you get to be a part of the decision. And as Isat said, you don't have to come with an attorney to mediation or RJ. You don't have to. You can come on your own. You can start the process. If that fails, then go to an attorney. But the reality is that it is so much cheaper for you to attend and try and get justice in that forum where you are making the decision. It is the parties there that make decision, not a judge, not a lawyer.
You know, as you spoke, I'm wondering if it isn't our actions aren't a part of our own cultural makeup in terms of how we see wrong, and that a wrong seems to always require some sort of punitive act.
Yes.
You know, so we don't see a wrong being resolved in sort of a discussion. A wrong requires some tap on the wrist, or some serious example being set, at least for some people.
And that is how they look at it. Watch me and you. I'm going to show you. I'm going to punish you. But the reality is the only person being punished is you. Because you still have not gotten an opportunity to tell this offender how it affected you.
Online is coming in fast and furious, but I'm going to also look at other things and then come in as they come. But it says, from your perspective, what are the 3 best and 3 worst parts of this ADR process? Well, I think you would have somehow hinted at that, but maybe it's a chance to reinforce, because it seemed to be a point of contention, distinguishing between restorative justice and mediation. So I think the focus here is, from your own perspective, what are the 3 best and 3 worst parts of the ADR process?
Well, for me, 3 best parts. 1, helping people to actually understand the other person's perspective. I'm not talking about restorative justice now, that deals a lot with criminal matters. Remember, mediation deals a lot with civil matters. And some criminal matters, for example, wounding and other things like that. But as I said, letting them understand the other, when they're in the room, letting them understand the other person's perspective, helping them to understand their options. So letting them know, listen, you're here at mediation. Let me tell you what will happen if you go to court. So letting them understand so that there can be a buy-in for them wanting to be there and wanting to actually resolve the matter. And just assisting in helping them to find a resolution. And when I say assisting, meaning the mediator is there to steer the proceedings, to make sure that communication between the parties are effective. Because the reality is, when you have an issue, when 2 people have an issue, they cannot hear each other. No matter, even when they're telling them the real thing that's going to resolve the matter, they are not hearing it. There is a block. The mediator, as a neutral party sitting there, listens and says, do you understand what Isat is saying? Are you hearing what he's saying? And vice versa, you ask the other person. Because invariably they're like, we never realized that is what was being communicated. So for me, the one of the best things is helping them to understand. Because even when you go to court, many times they go to court, they tell the lawyer, you know, what the issue is. The lawyer creates a case and goes to court. And even when them finish, you'll hear the people like, I don't even know why I'm carrying me go to court for. Why was I here? You know, so Yeah, so those are some of the best things,
Yeah.
things for me.
Okay.
Yeah.
And we're going to come to the worst. But yes.
Yes.
So Dr. Daly, you're going to look at the best and worst, or you're going to look at the best?
I'm going to look at the best, and I think you had asked a question too about the difference between the two.
Okay.
All right, so let me start with the best. So in addition to the issue of cost, it's cost effective, and it is less. It takes less time. But one of the things I was thinking about too is that it affords party the opportunity for their matter to be arbitrated or mediated by somebody who's an expert in the area. Sometimes when matters are brought before the courts, it may not have had the same experience in terms of persons who are dealing with the issue to resolve same. So that for me is one of the good things about ADR. Now there's a misconception surrounding what is restorative justice and what is...
I'm sorry to cut you, Dr. Daly, but I just want to make sure that just because you said something about arbitrated, I want them to understand. I don't want the listeners to think that when you're speaking about matter being arbitrated, because we don't arbitrate as mediators.
Right.
We don't make decisions. We don't make decisions at all. The parties make the decision. But I think what you're trying to communicate is that when a mediator has knowledge of a particular area, so if, for example, if somebody comes in to a mediation and it's a matter to do with construction, for example, then we can understand, the variables that go into, construction and the details. That when somebody's angry, there are some questions that we can ask as a mediator because we have more knowledge of that particular area.
Yeah,
you don't have to, but it helps.
Yeah, thanks for the clarification. Now, coming out of the survey, a lot of users and non-users were of the opinion that both mediation and restorative justice are the same. And it's a belief that is common among the wider population. Now, if you look at most jurisdictions in terms of how they differentiate mediation from restorative justice, it really boils down to the source or the nature of the case. So in the context of restorative justice, these are usually matters that are somewhere within the criminal justice system where you are able to definitively identify who is the victim and who is the offender, right? As opposed to mediation, these are usually matters outside of the CJS, the criminal justice system. So, for example, family disputes, usually... Family
disputes, neighbors, car accidents, somebody get injured, personal injury, those are more the cases. As you said, not the rape, not the wounding, stuff like that were more passed to restorative justice, if I'm correct. Isaac.
You are correct in that, save and except for, I like to make the distinction that where restorative justice is concerned, it is really at the community level. It oftentimes is a preventative mechanism.
Yes. Yeah. Yes.
And the disadvantage of it is that some of to be preventative, you would have to identify. One of the tenets of restorative justice is identifying who the victim is. You must have a clear offender and a clear victim. That sometimes the lines are blurred, especially as, again, I would have said earlier, the reality is that even with restorative justice, the conflict is wide. In other words, persons are in family conflicts. I don't like my brother. Really, the reason I don't like him is because he won't go out and go move somewhere so I can get the house for myself. And time is passing, so we entering into the realm of fighting over family land. And so we have to get him out. So me and my kids ensure we start to fight him and his kids, and then violence comes with it. But the underlying issue is actually the land. And so with restorative justice, that can sometimes be the downfall. But as I would have said, currently restorative justice is funded by the government in terms of access to it. There's no fees attached to it. From my understanding, I don't know if that has changed yet, but certainly the only downside is that persons aren't aware of it, and there needs to be more awareness, especially in the courts. We need to use it, because one of the things, if I never leave, I have to say this, is that we need to move away from making ordinary citizens into criminals.
Yeah.
We should never be in the business of that, and that's what ADR is about, to resolve conflict and get persons to empower themselves, be their own judge, be their own attorneys, and be their own decision makers, so that we can have a civil society.
Yeah.
That's my...
And to engage the process in a more empowered way. That's
Right.
beautiful. The three worst parts of the process. Who wants to take that on first?
I can go first. But
Go first. Yes.
I can readily think of one. So in ADR, especially when we talk about mediation, it is very flexible and it's voluntary. And so in many cases, it may not offer that level of safeguard as opposed to if the matter was brought to trial before the courts. And so you run the risk of unintended outcomes from these sessions. So for me, that is the, one of the worst things about ADR.
Not sure I agree with Dr. Daly on that one. Meaning, when I would have gone into, if I was to add a best and then come back to the worst, one of the great things about mediation is that the parties themselves come to a decision. It's about compromise. So you have two people sitting down in there saying, listen, I know that this is, that I hit your motor vehicle and I need to pay you money. I don't have this kind of money. How we can, I don't have $1 million to pay you. How we can compromise? And they work it out. As against, for example, if you had gone to court. A judge is not about working out. The judge is looking at, this is the value of what you have done, you're going to pay for it. Whether you're right or you're wrong is whoever present the better case, and then there's a decision made on that. In mediation, the parties get to make the decision as to, and so they will stick to the agreement. They get to make the decision as to how, as to the outcome. But the worst thing for me with mediation is usually when parties come, if they come without attorneys, they don't come equipped to participate. So they come and they're really rushing in, boy, I only have X amount of time because I have to go to work. Then if they come in to say, boy, I want them to repay money for something, they don't bring no evidence to say, well, this is the receipts here, this is what it cost me to replace the shoes or the whatever. And if you come with attorneys also, I found the worst part of it is also not coming prepared. So for example, a personal injury matter where the client has been injured, they come to the mediation and then the other party will say, okay, your client was injured, let me see the medical report. Oh, we don't have the medical report. We just want to know whether or not you think your client is going to accept liability. But the reality is many mediations are resolved, not necessarily because people think, I did something, but when they look at the overall cost, boy, you know, if I wait 5 years, I don't know if I'm going to get this kind of, if I'm going to win, I don't know if I have that money, it's taking up my time from work, all of these factors. So the worst part for me is attorneys and clients not coming prepared, or they come to mediation and all the parties who should be a part of the mediation are not there. So you have people come and they say, boy, yes, you know what? I would take this $1 million, you know, but I forgot to call my mother. They don't tell the mother, well, I'm going to mediation, make sure you have your phone on and whatever. That wastes time, because then we'll probably have to come back. Lawyers, many of them who are doing some of these matters, they're employed by insurance companies. And they will have to adjourn the matter because, again, the insurance rep who should be a part of the mediation is not available. So it's about not getting, you know, information right then and there. So those are some of the worst things about mediation for me, the lack of preparedness.
I thought this is not going to raise your pressure. There's another question online that says, the police and restorative justice centers do not have the space to host private discussions. So why do we even trust these sessions?
I see that I was going to answer that before I was preempted. So I have it right here in my head to answer. You see, this is the thing about it. The human factor is the worst part of ADR. Because you can barely trust your family and your friend them. You come to this stranger and you're going to air out your business with the stranger. How getting the parties to understand that, listen, confidentiality is something that the facilitators, that the mediator, that all the persons in the room are bound by the confidentiality clause within a session. And so the important thing is that if somebody was to breach that confidentiality, it's actually criminal. So you are free, even as the offender, to say, which happens a lot of times, and it makes not even the victim, but members of the family in a RJ session, in a victim, especially when you're dealing with juveniles. When you hear a juvenile say, yeah, I take out my ratchet and I slash off him face because the boy did a diss me, you know what I say? And a parent hears that, and you know the session is pretty much done right there. But so these are some of the downsides, but the reality is you want to get persons to tell the truth, and you want persons to ventilate the issue. So where trust is concerned, I would agree that was a good question, because the biggest downside is not having persons to trust you. So it's all in the facilitator. One of the key things about restorative justice, and I'm not advertising for Miss Miller, but the comfort that you get when you're in a mediation with Miss Miller, you start to talk about, a lot of times the parties leave wanting to resolve the situation.
Yeah.
The thing with restorative justice is that there's a ball or a talking piece. The person with the piece has the power, and you're obligated to listen and wait your turn. These are things that we don't even do on a daily basis. We're on this panel and I want to jump in. Yeah. We have that. We don't listen. We just always want to contribute. So in terms of trust, getting the facilitators to ensure that they communicate with the parties and give them opportunities to say, you know what, I like your vibe, or what we say usually in Jamaica, my spirit take you. When we get there, we're getting back to the humanitarian part of it. And I can say to that particular person that in terms of RJ, it's not necessary. If RJ is not at the police station, it's at a particular center. It's in the community center. And if you're having issues, this is why it takes some time to set up that circle, because it may very well be that they have to find a venue that can, depending on the particular issues, that persons can go and get the necessary confidentiality.
And just to add to that, I'm sorry, and you hardly speak, so I really should not, but since I might not remember,
go ahead,
I'm taking age above that. Right, and just to also say that for mediation, they're held in a neutral space. It's a neutral space, and everybody has to be comfortable. And as Isaac said, the facilitator, like myself as a mediator, you have to let them know it is confidential, and actually a document is signed prior to the start of the mediation to say, I hereby agree to keep it confidential. My notes are torn up at the end of the session. Nobody can call me to do a mediation or tell me to repeat anything. So everybody has to be comfortable, and that is very important for any of these ADR processes to be effective. People have to be comfortable in the setting, comfortable with the people, feel relaxed, feel like there's no bias there, not sitting there with somebody and saying, but hold on, Isaac kind of look like Mr. Bent. I wonder if they're my cousin.
Yeah.
In fact, you have to disclose. Everybody has to be comfortable before it starts.
Okay. Yes.
Yeah, just briefly, one of the ways to build trust is through education and training. And the minister has recently committed to such in terms of training, providing training for suppliers of mediation and restorative justice services.
Minister? Education, justice? Justice,
right.
Okay.
And an education campaign to inform the population about the utility of engaging in these ADRs.
Yes.
Okay, so there's another question coming from online that says, seeing that the CSJP is not complete, is the Ministry of Justice equipped to manage the restorative justice process?
So I will say, so the
think
question
there
is coming from a basis that there aren't things in place. But I can say this, that the credit to the minister and the stakeholders,
Yes.
there have been centers that were opened for over the years between the last 3 administrations. So both administrations, and Mr. Chuck certainly has the St. Andrew one, which is right in the middle of Halfway Tree. I know there in almost every parish they have these centers.
Yes.
The thing is, what needs to be done is that the public needs to be aware that the facility is open to them. The new talk should be, you know something, me I go RJ before me do you something, you know. That should be the new conversation. It is there for you.
Yep.
So when somebody says this is not complete, there are many aspects of it, and so I promise you, I can speak for Mr. Varaldo Barnett and some other in August Town. There are many, the ones who I know, the facilitators. All you have to do is present yourself, and you have, with RJ there are pre-interviews, so the offender might be, you can have the interview long before the healing circle comes together. So the facilities are there. It is just a matter of public awareness and getting the public to understand what exactly do you need to do to access the services, because I have it right here from the beginning. Access. It is effective, it must be accessible.
Yes.
That's what the conversation should be about, accessing the system and educating the public.
Yeah.
And
Yeah.
we need to understand that the public, especially the persons who need restorative justice, them not tech talk. So the facilitators have to be able to transcend the levels so people can understand. Language is everything, because people are going to say, where am I come from with him little uptown self? I come try to tell me about. No, sir. You're not going to get anything. So access, education, communication, very important.
Question directly to Claire. What is the role of the DRF, Dispute Resolution Foundation, I would think, in advancing restorative justice and mediation?
Well, as I had said when I started, they are the founders. They started in 1994. They are like the columns. They're very invested in both. They have a building situated on North Avenue, where as a facility where you can go to actually have your mediations. We don't do RJ there, as far as I know. It's a separate thing altogether. As I said, we can't confuse them. They are very separate. But in terms of mediation, they are the hosts, they are the referral agencies, courts refer matters to them. There's a roster of mediators that they have, so you can call them, look online, see the roster of mediators, and choose from there who you want to be your mediator. You can call them, ask them any questions at all. They train mediators as well. They don't just have mediation sessions there, but they also train mediators. They also are very involved in a school program where they work along with the schools for students who may be suspended or going to be expelled, and they go into it's called the school intervention program. So that's how they are involved. As I said, it's a mediation center. They're not involved with restorative justice, not as far as I'm aware.
So we talked about this idea of getting people from across the divide to share. So we're getting not just perpetrators to talk, but also sometimes the victims themselves to also be able to say to someone else that you did this to me, and this is the impact you've left on me. A question is asked: what is the support for victims after mediation and restorative justice sessions?
Well, for mediation, as I said, we don't have that kind of support unless you're going to go to counseling, because we are not counselors. We really are there to provide a safe haven for you to talk and to say anything that you want to say at that point in time.
Okay, so let me figure out if this is the mindset of the questioner.
Yeah.
I guess they want to know if it is you open the floodgates of emotions such that someone is letting out that level of hurt
Okay.
After they leave that space, what is next? Do they take that hurt and they leave? Or is there some sort of mechanism that will allow them to further address that issue? You're saying that's not necessarily the role. Your role is to flesh things out within that space.
Right.
They should then realize that this is a deeper issue that they should probably seek help with.
Right. And also, what happens, as I say, in mediation, the mediation process is usually, the first session is usually at least 3 hours. You can use any amount of it without there being an additional charge. If you want, I've done mediation for 7 hours, non-stop. I've done it for 12 hours.
Wow.
Yes, non-stop. We order food, we do everything. We're not moving because it's so sensitive. You don't want to leave with people, going through the door with certain things still on their mind. So as I said, it's a safe haven for people to spill their emotions. And if they think they need to come back, then we say so. Any skilled mediator can sense that kind of distress. And you're not going to leave the parties in that kind of distress. We're going to sit and try and flesh it out to a point where everybody feels comfortable leaving. I give you one very quick example. I remember doing a mediation, similar kind of thing. It was a custody of a child. And the one party was very abusive, unfortunately. The male party was very abusive. I could tell that the lady was intimidated, in spite of the fact that they came with attorneys. And we had gone through, and they came to a partial settlement of the mediation. And we were supposed to come back. But just as we're leaving, I remember I overheard when the gentleman said to the lady, "You think it'll go so?" And I said, no. We are going back inside. We have got to go back inside. We cannot leave with that kind of discontent, because that's not what it's about. You have to spill and be honest. So as I said, you have to be trained. Sometimes I take the attorneys out the room. I just leave the parties themselves. I said, come, let us talk. Because sometimes some parties are embarrassed to say what the real issue is, even in front of their attorneys, believe it or not. And when I sense that, I ask the attorneys to just give me some time with them alone. So to answer her question, any skilled facilitator, meaning mediator or restorative justice person, should be able to help them to a point where they will not feel that, oh my gosh, after spilling my belly in here, that I could be open for other repercussions. If it's just an emotional issue, they can do counseling after.
In terms of the RJ aspect, as I said, it is a healing circle. The victim has a support system, so you have your family members, you can bring your pastor. It doesn't include the attorneys or persons who have other interests involved in terms of time and money and stuff like that. But the healing circle is that type of environment where when you ventilate those issues, you get the person sees you pouring that emotion out. And I can tell you from experience that even being an observer and seeing how somebody having the opportunity to ventilate their issues, underlying issues, and how the offender responds in that situation, and oftentimes when they're more similar than not. And so the mechanisms, there is victim support if it's a domestic violence or if it's a sexual offense and stuff like that. The facilities are in place even after the healing circle. And again, it's victim empowerment, and the persons make those decisions.
Dr. Daly, from the research, did you find people having a positive feeling towards either ADR or restorative justice?
Okay, so let me start. Okay. ADR or legal aid services. Okay, let me start with legal aid services. No. In fact, a lot of persons are of the dispensation that legal aid services are usually in favor of the state, simply because it is the state who is funding the service that is being offered. And sadly, based on history, usually these matters are, the outcome of these matters are not in favor of the client. As it relates to ADR, restorative justice, and mediation, it's the complete opposite for those who use the service. Persons have expressed that there are some persons, I mean, let me say there are mixed emotions where ADR is concerned. Some persons have expressed that they are satisfied with the service, while others have said no.
Okay. So I think this is another follow-up question to the person who is intent on making people go to prison. So the question is, what does making amends mean? And the next question is to clear about what does the pre-meeting entail? Pre-meeting.
Pre-meeting.
Right.
I'll answer this one. I'll leave amends to you. Pre-meeting, we don't have as much of that in mediation here in Jamaica. I know for a fact they have it in the UK. And what that usually entails is, and I would encourage it here, it's just that because it would probably also come at a cost, it's not so advertised. But pre-mediation or pre-meeting is really when the parties would get together with the mediator, and we would want to know if you are ready. So just as I said before, let us say it's an accident matter. Persons will say, we need to have mediation by October 20. I would be asking them, do you have your reports? Have you spoken to your client? In other words, is everything in place? Do you have the witnesses? If you would want somebody else to come to the mediation, are they prepared? Just making sure, as where the attorneys are concerned, that they have all their documents. If no attorneys are involved, and it's just, the parties without attorneys, I'd ask them the same thing. If it is that you're saying this person assaulted you and, rip up your blouse and you want back the money for the blouse, do you have the blouse? Do you have the cost of the blouse? Do you have the receipt? Do you have a similar cost? Any evidence? What is the evidence? So the pre-meeting would be really to make sure that they're ready to have discussion. Because for me, I can tell you, a lot of mediations are either adjourned or cancelled because people were not prepared. They either were sitting there waiting to have a mediation, the client is not there. When last did you speak to the client? But I told him last month, no, you cannot speak to the client last month. You would have had to have spoken to the client at least a week ago to let them know this is what is coming. Then 3 days before, and then maybe even the day before, please remember the address, making sure that everything is on board to have a successful mediation. One more thing, just for the person who was speaking about spilling the emotions and perhaps the safety, just to also say that in the mediation sessions, before the mediation sessions, people are also searched to make sure they have no weapons, just in case. So some people might say, I know him have a gun. No, we search. They're searched. They have to hand over any weapons, knife, gun, whatever, before entering the session as well.
Okay, so
Amends.
Amends, and I hope you can tag on this other question too. It says, is restorative justice just for crimes that have been reported to the police?
Okay, I'm glad.
No.
Beautiful question. Let me start with the amends, the making amends. So again, the word is forgiveness, and we're talking about a healing circle as the foundation. So when the offender make amends, one of the things that comes out of a restorative justice circle or session is that the parties do it with a view to enter into an agreement where the parties give an undertaking as what is the way forward with the community, the offender and the victim. Right. So that the offender may have harmed you by destroying your property, bringing harm to you by physical harm, and think of all that money at the average case. Let's say an offender would have had to fine $1 million to go through 2-3 years of a court action. They may agree that if it was that I broke your leg, rather than you having to go to a civil case even after the a criminal case, is I will pay your medical bills. I will assist you. I will undertake not to bring no harm. I will undertake to ensure that I'm moving forward, because I'm not going to be convicted. This is in my interest that I will change the person that I am. I will become a productive member of society. And I tell you, that type of self-recognition and that type of, you sign to that with the understanding that if it is that you breach the contract, the very officers that gave you the opportunity to go to restorative justice can come back then and send you to the court. So restorative justice is preventative, and it is that type of empowerment that we want. As every time I get the opportunity, I always say we ought not to be in the business of turning ordinary men and women into criminals, because there's many things that affect how one life, and so many things that's affected by it, both for the victim and both for the offender. And we also have to understand that with the making amends this is key. If you have someone now understand what it is that they did wrong, there's no bitterness from 10 years or however harsh it is that the criminal justice system might deal with somebody who otherwise had underlying issues that made the mistake, is that they have to be in the same community. Jamaica is not as big and as large as people put it out to be. You know, you run into people all the time, every day. So that if you are in that position and you come to that agreement and you, the victim, is satisfied that this person is making amends, then I can forgive and live in the same community with you.
Fair enough.
And that's important, because if you send me to prison for 10 years and I complete the 10 years, I'm coming back to that community. I paid my debt to society, and you have to look in my face with no amends. You know, I don't make amends, and I'm probably even angry at you for the rest of my life.
It says here, how long do you feel potential users of restorative justice or mediation should have to wait before having at least a first session?
Well, I think once users are ready, it should happen. So if there's something going on in the community now, or with the offender and the victim, and they want access now, that should be able to happen. Should be able to find a facilitator, and everybody. Same with mediation.
Right.
Once you're ready for it to happen, there should be mediator ready, facilities ready, everything should be in place. But having said that, to get the best results, I would say for RJ, maybe within 5 days, if it is possible, and mediation within 30 days. And I'm only saying that because, as I said, a lot of and I'm talking about 30 days if it's, say, going through an attorney.
Okay.
Because you want them to be prepared. But for parties, it can be immediate. But I also say within a 30-day period, so that people don't get relaxed. You want to do it while it's still hot, you know?
So my response to that, sorry, is it's on a case-by-case basis. Again, like I said, when it comes to what we call the healing circle, your pastor might not be available, your mother might need to fly in, your support group might not be available for restorative justice, that is, and also the victim may not be ready to face the offender, or the offender is still embarrassed and cannot face the victim. So you can't put a timeline necessarily on it. Safe to say that whatever RJ and mediation is about, I promise you, it is more efficient and effective than the court system.
Yep.
So one must always remember that.
Right.
When you enter the court system, prepare for the long haul and the inconvenience. And still today, I always pray, especially for victims. I feel sorry for them, even as a defense attorney. It can be the most humiliating and embarrassing experience to go to tell your story before a court.
In short, ditto. But coming out of the survey, it was revealed that it took 16 to 36 days. But I agree with you, Claire, in terms of it can only start if both parties agree mediation or RJ.
Another question online says, is there compensation for victims in cases of mediation or restorative justice? Do victims get compensation that is in line with their losses, or is it more of a symbolic reparation?
For mediation, I would say yes, they do, because that's, you come there and it's a discussion, as I said, that you're going to have. It's not just a figure that you pick out of a hat. If you come with an attorney, the attorney would have already done the research to say, listen, your claim is valued between, let us say, $500 to $1 million. And then that's where the negotiation starts. Parties start to say, well, can I accept the 500? Do I go to million? Do I go in between? And that's where the negotiation and compromise starts. So yes, usually it does. And then you also have to factor in that even if somebody's proposing a figure, you have to look down the road. Because remember, court is not sure. Just because no matter how good and clean a case it looks, listen, this man just come run up in the back of my car. If you can present that accurately to your judge, between yourself and your attorney, you may lose that case. So all of those things are factored into saying how you negotiate, how you compromise. Do I wait the 5 years? Do I take the money now and take it at this value? You know, so usually all of those things, you know, are discussed before parties accept to pay or to receive the sum. So yes.
And the answer is yes for RJ and the restorative justice. And key thing is that for both mediation and both RJ is that it pulls the rug from under the court when an agreement is made, so that the court no longer has jurisdiction when the parties who empower themselves come to an agreement. And so in that agreement and making amends is the part. Making amends includes compensation. Okay. So if you were hurt, the option with RJ is not whether you will get compensation, but in an agreement, the timeline for the compensation. Because remember, with RJ, I can say the persons who participate in restorative justice, they're not always persons of means. And so if a man is selling at the stoplight, he may say, I can bring in $2,000 every 2 weeks until it adds up. And the person might say, you live in the community, I understand, just bring it every 2 weeks, and it adds up over time. So the answer to it is yes.
I think this is something that's in similar line to the question. Is there a limit on the time that has elapsed since the crime was committed in order to proceed with restorative justice?
No. So something that you have to understand as well, restorative justice can take place even after somebody is convicted. Because again, we must always remember that the victim empowerment and closure for the victim may take place years after. If you watch TV, there are persons who commit murder and the mother goes 20 years later to visit the person to say, I forgive you.
Right.
So it's always important to know with restorative justice, healing is the key. And so it happens, it doesn't matter. If somebody has harmed you and you need the opportunity to ventilate that, you can approach RJ and the facilities are there to have that healing circle because you live in the same community.
If you could change one or more parts of the mediation or restorative justice process, what would it or would they have been and why?
For me, I would change the way matters, a lot of the court matters come to mediation. So usually court matters come after you have started the process. So you have to file a claim in court, and then at a particular stage, after you file your claim and there's a response called a defense, then at that stage, that is when mediation is usually recommended. My thing is no, let us start at that beginning. You cannot file a matter in court unless you have done mediation. If we're serious about getting rid of a backlog in court and helping people. And also the benefit of that is it's private. It's between me and you. We have a discussion. Let us go and try and work it out with a neutral party. As I said, you don't have to come to mediation with a judge, with an attorney. Parties can come by themselves. So start there. Let us find this neutral party, this mediator. Let us discuss the matter and see if we can get it resolved. If we don't get it resolved, let us go to the attorney. Let the attorney then come to mediation with us. If that breaks down altogether, then you file your action in court. So it preserves your privacy. Nobody has to know, because once you hit a matter in court, once a matter is in court, it's a public. I have seen matters, you know, when I was at law school, there were matters that were coming up, and some of them were my friends' parents, you know, divorces, everything out there in the public. When you have mediation starting before you file a matter, it's still private. It still preserves the relationship between the two people that are having the problem. So all your information and your business not out on the street. So if I could change something, it is where we now have the slot for mediation. Have it first. If you have not participated in mediation, do not file, you know, do not file your matter. They used to do it with divorces years ago. You can't get a divorce unless you have gone to counseling, right? So I say the same for mediation, for court matters. Change where it is.
I'm not sure if what I'm thinking is in line with what you're saying, but I grew up in rural Jamaica, and most times domestic dispute ends with someone calling the police. When the police comes, nobody's really giving any real report. They just call the police to scare the other family member. But nobody wants anybody to go to prison, really. You know? So the police is supposed to come and warn the person and then leave.
Right.
But no action is supposed to be taken thereafter,
Right.
because the same party who called the police will cause a problem if any sort of arrest is made, because that
Correct.
was not the intent in the first place.
Right.
The police was supposed to come and bring fair, and that would have resolved the matter until the next quarrel.
Right.
Then you would call the police again.
Right.
Within that segment. Would mediation, one, save people like those
Yes.
from the public spectacle,
Yes.
but also sometimes from wasting the law's time?
Yes.
Because the police coming to just say behave yourself, or just coming to look around, or trying to find the spouse who is no longer there once the police is being called.
Correct.
It makes no sense.
You're perfectly right. And as a matter of fact, this is one of the reasons why, for me, when I spoke earlier about sensitization, everybody needs to be sensitized. Our police force, it needs to be in their curriculum so that they understand the benefits of mediation and restorative justice. So what would have happened in that case that you just said is that the police who knows and understands the benefits of these ADR processes would then say, you know what? Come to the station tomorrow, for example, and then I'm going to give you, recommend a mediator for you, and
Excellent.
you go and do this. And after you have done that, so you know, that way everybody feels like, yes, you don't get away.
Yep.
You can't do it again. The police still know. But if you don't do this, just know I can come back for you. The next time I come, it's handcuffs.
Yep.
You know what I mean? And that's if the police know. So that's why they too have to be sensitized. They are critical to what goes on in society. No.
So, yeah, I would say the one thing I would change is in recognizing that Jamaica is a high crime society, and we cry about the murder rate, and rightly so, is that if our justice system could focus more on the serious crimes such as murder, and where mediation and restorative justice, if the police force is trained, then it's so much easier for them to say, you know what, instead of locking up, especially in this COVID, this is the new normal, instead of locking up everybody for domestic violence, or for you know, certain, even the stealing of a cell phone, let me go that far, to say, you know something, what I'm going to do is you guys are going to go to the restorative justice, you're going to do this, you're going to see if it works out, then we won't have to prepare a case file and send it to the court. So the community, again, can resolve their issues within their little communities, and then it wouldn't be so, the criminal justice system wouldn't be so overloaded if you see some of the cases in the parish court, I feel sorry for the judges. And then some of it is now kicked over, as in the stealing of a cell phone, pickpocket. Parish court filled with that. That could be resolved with restorative justice and help the offender as well as the victims. Let's bring the gun into it, because that now is a Supreme Court matter, but it's still a cell phone. Even that can go to restorative justice and help that person to be able to speak the truth. Because sometimes a gunman may not even know why he's a gunman. I always try to wonder where you find money to buy bullets. These things can be resolved in restorative justice, and we can get access to getting guns off the street, all of that, instead of trying to, again, make ordinary men and women into criminals.
Dr. Daly, in terms of different subset of the grouping that you'd have spoken to for the research, did you find that people were ignorant as it relates to the justice system, or they were fearful of the justice system ability to, one, protect them, or two, give them the sort of justice that they desire?
Actually, both. So there were a lot of respondents who did not know about these services and the benefits of these services. So certainly, yes. In terms of the phobia for these services, yes. And as stated in the presentation, based on experience, whether it be second-hand experience or first-hand experience, they are of the view that, especially when you access services such as legal aid, usually it does not reflect your wishes. So certainly both.
Okay. I start to think this is...
Roger, if I may, about the question about what I would change.
Yes.
So, as I alluded to earlier, not necessarily change, but improve is how we bring across information to the general public. It cannot be that as a society where we strive for pure, efficient justice system, that our primary agents for disseminating information about ADR is not stakeholders within the service itself.
Right.
So for me, it would be the justice sector playing a greater role in terms of public education campaigns to inform the general populace about the importance, the benefits of utilizing ADR and legal aid services.
It says in one of these questions online, as I'm trying to sift through them, it says that what if the other party later refuses to follow through on agreement that would have been made in mediation?
Oh, that straight to court.
Mm-hmm.
So you can enforce that agreement, but you wouldn't have that weight that you would have like when you're starting an action from beginning. You can go to breach of contract immediately.
Mm-hmm.
You know, file an action in court. So it's not lost. It's not lost. If you go and you make an agreement and it doesn't happen,
right,
then you file an action saying that this agreement has been breached. But the documents that an attorney would have to prepare associated with that would be far less than if you're trying to convince a judge
Mm-hmm.
of who is right and who is wrong.
Mm-hmm.
Because remember, in the agreement, the person has already said, yeah, I owe you this.
Mm-hmm.
What you have done now is not pay me, so I'm going to take you to court based on that.
And that person would have probably would end up paying far more,
and also paying and breach of that court order. You reach jail, prison.
Oh, okay.
Yes,
That's clear.
that's very clear.
Claire, this question is for you.
Sure.
Based on your many hours of mediation, what factors would primarily influence clients' decision to settle disputes in a timely manner?
Well, one is the actual cost. The cost, when they see the cost that they're saving to take a matter to court, that usually factors in. The other thing is, again, depending on the facilitator, allowing the parties to be able to be heard and get respect. Respect is a big thing in a mediation. So I find that people relax more if they feel that they're being heard, right? So, so that's another one. And also the unsure outcome. You really do not know what is going to happen beyond mediation. So my duty is to encourage them to use this time to talk it out, try and resolve it, because there are a lot of innocent people in prison and a lot of guilty ones on the outside, just because some people just can't set a case properly. As I said, depends on the judge, depends on the attorney. There are too many factors weighing heavily against you actually succeeding when you go into court than the benefits of you just coming together and trying to resolve. So I usually try to encourage them, as I say, look at the cost to you. Also, look at the fact that you're preserving a relationship. Do you really want to sue your brother and knock this out in court with a human being hearing all of your business from start to finish? You know, in mediation, it's private. Let us resolve it here. Let us get a private agreement. Nobody has to know about this agreement unless it is breached. You know, and so
I don't want you to give away your ingredients or any of your secret or anything, but I want to get into your mind a little bit, because
no problem.
As much as you've said, listen, this thing is law, it's not psychology. It has to be psychology. There's a whole lot of psychology going on.
It is more psychology than
law, right? So
there's no law.
So there are two people getting into that room on opposite side of an issue.
Yes.
How do you get them to that place in the middle? I mean, do you offer them coffee? Do you play a type of music, some Chopin? Or, do you allow them to talk? Or how do you break down that issue to the point where they feel that this space is mine enough to share?
Right.
That's one. And two, that this space is sacrosanct enough for me to be valued when I do share.
Wow, amazing question. And I say that because this is not always something that you can teach a mediator. I mean, from my own experience, I've been mediating from when I was in high school. That is just my natural thing from day one. But when I come into a room, believe it or not, I look at the people. I invest in the people who are in the room, from the clients down to the attorneys. I look in their eyes. I make them trust me, because they don't trust each other. And although their attorneys are there and they may trust them, they still know that, listen, you have another case tomorrow. The only neutral person in that room is me. So I need you to understand everything that I'm about to say to you. So I need them to hear me, because they're not hearing each other. So many times, as I tell you, they are saying the same thing, but because there's this block, all they're seeing is what happened the last time. You hit me down. You never even stop and carry me to hospital. You never come back and look for me. No matter how much the other person is saying, I wanted to do this, but I couldn't. Everybody tell me if I come look for you, it means I'm guilty. That. They're not hearing that block. They'll hear me. So when I get them to express themselves and I look at them and I give them my full attention, and then I say, do you understand that this is what the other person is saying? And I translate it. They hear me. They can actually hear me and put themselves in a position to, I need to listen to that. I also look at the people in the room, and believe it or not, I can weigh the egos in the room, because enough ego in the room. Especially when you come with attorneys, because lots of mediations fail too because of attorneys. Attorneys fight attorneys. It could be a simple thing like Isaac and I were in the same class, but guess what? Isaac is a A student, I was a C student. No, come here, come win my point. Anything me say, go and go. And it totally distorts the mediation. Then you have the clients who are in there and stiff as board because, they just don't get on. But who do they trust? The mediator, because I have nothing to gain. So in trying to get them to a resolution is first to let them hear, let them buy into the process, buy into their options of why they are here, let them understand, the reasonableness that has to take place here, and the spirit of compromise, because they both can win. Letting them buy into the fact that you are the ones going to decide this matter, not me, not a judge. Do you really want to take the chance and go to court for a judge to make a decision? No, you don't want to take that chance. So it's all of that. It's a lot of gymnastics. When I come out of a mediation, I'm tired. If I'm doing it properly, I'm tired, because I have to focus on body language. I have been in mediations where, yes, the attorneys are there, but just how the client is sitting says she may have a problem with her attorney. And this is a real situation. And so I asked for just a meeting with just the client. And I say, what's going on? You don't look like you're so comfortable in this situation.
Right.
And I said, she's not, because she doesn't want to disappoint her attorney. Another child custody case, and the attorney was suggesting to her to take more than what the man was offering. But really for her, she really wanted to keep the man in the child's life.
Right.
But she didn't want to disappoint her attorney. So her body language of how she was sitting made me say something is not right here. So you have to look at everything. It's not just what's on paper. Yeah. It's not just, it's a whole lot of things.
It's a whole lot. I can just
psychology.
imagine.
It's not law, because we have a lot of mediators that are not attorneys.
Okay.
Right? So it's not law.
So it's a whole process in terms of having to look at that layout of the room,
look at the layout,
and just to figure out the actors in there,
yes,
and what are the motives.
Make them comfortable. As Isaac said, that's one of my things. I'm invested in it. I want people to feel comfortable to talk. So if you go in there straight-laced and stiff-jacketed, they can't understand the language. You have to assess the parties in there. What language are you going to use? Are these people that can understand everyday language? Talk the language. Many times I go in there talking about what's going on now. So it's COVID, and remember to wear the mask, how you doing, how you treating you. You have a little banter before the actual mediation, so that they know they're not in an aggressive space.
I thought this may be actually pandering to a stereotype, but in a culture where badness is celebrated, and going to prison may be a badge of honor. How receptive are some people who would have done bad deeds? Are the first person to suggest, how receptive are they to restorative justice? Are they the ones to say, I'm open to it? Or generally is it something where an attorney brings it to them as a possibility? Because in a culture where badness is a good thing, you actually going to someone to apologize or to hear things that that possibly make other people cry, or even make the bad man cry, it wouldn't be an ideal circumstance.
So
have you seen bad men cry?
Bad men. So I don't want to sound like a hypocrite or that I live in Disneyland, but I don't subscribe to those labels.
Okay, sir. Fair enough. I know that I remove them.
No, it's fine. No. Why I say it that way is because we have to first understand that persons are put in circumstances sometimes they don't even want to be in. Sad to say is, in my experience, nobody knows what restorative justice is. Nobody knows what mediation is. If you say it to somebody, them say, but what that? That is always the response. And so I do know that persons, they trust their attorneys. They think that attorneys, for some strange reason, I don't know why, that they're high and mighty and they're gods. So they rely heavily on them, to the point that when you go to the prisons and you said, did you tell the judge this? No, my attorney never give me the chance to speak. That's the most disheartening thing. So the offenders don't get the opportunity to speak, because sometimes they go through an entire trial, they don't give a statement from the doc, or they don't even say anything. They just, you guilty, go serve you. But you say, but what happened? And then you hear, me's not a bad man, sir. I never did this, or I didn't mean to do it. And sometimes they just really didn't mean to do it, but they need that opportunity. So they are receptive, even victims sometimes. For victims, the most thing, and if you are human, if you're in a car accident or you're in a robbery or you're in a you always want to know why. We always want answers. And so for that reason, the offender wants to give the favorite thing, and Claire can tell you, guilty with explanation, Your Honor.
I've heard that before.
That is the most consistent plea in the parish court.
But Isaac, do they come forward? Do you find offenders coming forward or victims come forward? Who comes forward? Do they ever come forward first?
The offenders?
Yeah.
No,
say,
because they don't. No, we are in a society, which is why I'm saying we need to kind of dress back from the criminal thing. Because even persons who do things by accident become liars because they already say nobody is going to believe me. And so because of that, we turn persons into bad men because they run away because they know nobody is going to believe them, and that cycle continues. And so they don't know they can come forward. Even this is something I have to say, they don't know that in a mediation you can tell the truth in the mediation, and if it don't work out, it doesn't go before the court. The judge won't know, the judge won't hear. Or the judge is not supposed to know and is not supposed to hear. But the most important thing is it cannot be used against you. The victim cannot come and testify and say, but him did tell Claire, say, him stabbed me. No.
That's all the beauty about mediation.
That's the thing.
Anything said there stays there. You
just
can't
like
use it in court.
I was just about to ask that question. So, as providers of ADR, you sign a contract of
Yes, you sign a
confidence.
contract prior to.
So, can offenders or victims be held liable for exchanges in the process that may be deemed inappropriate, in some cases criminal, during those sessions? No? No? Okay.
They're free to speak. I allow people to speak.
Even to threaten? Even if they threaten
No,
someone?
no threatening. Threatening is not a part of it, because that's why you're there.
Right.
Definitely
the
not in
example you
mediation.
gave earlier with the
That's why I brought them back in. So when I heard the threat on the outside, I brought them back in, because I'm like, no, we're not finished. Because if you still are steeped up like this, then that means you are not really truly a part of the agreement that you are signing to. When the effect mediation is supposed to have is that when you sign that dotted line, even if you're not getting what you want, you feel better because you were a part of making that decision. So when you go to court and a judge going to say, you have to pay the $100,000, a judge tell you that, whether you like it or not, you're not paying it. When you're in mediation, you can explain to the other party, I know it's $100 owe you, but I only have 80. You can take the 80, yes, I will take the 80. How you going to pay it? And he says, you know what, I can give you $10,000 a month. Whereas when you go to court, the judge is not necessarily going to take all of those things into consideration. So you find more buying when you come to mediation and the two of you make the agreement, because it's the two of you say it. It's not a judge imposing a decision on you. We both make this agreement. So I find that in cases like that, you usually find there's no matter going back to court. People stick to the agreement because they made it knowing their circumstances. And I always tell them, nobody said $10,000 a month if you can only pay 8.
Right.
Say exactly what you can do and let us know what we have to deal with. Yeah.
Certainly a robust discussion to date. We're coming up on a wrap, which is amazing and fulsome in terms of, I think we've gotten quite a look on ADR and restorative justice in terms of, a lot of people would have asked those questions. Some people didn't know the distinctions that would exist. The final question for the panel: from your perspective, what is needed to increase the number of civil matters handled by the legal aid clinics in Jamaica?
Wow.
Let me start by saying that to my knowledge, the legal aid clinic does not provide civil service. They don't provide attorneys for civil matters.
It's criminal.
Legal aid is completely criminal,
Yeah.
and is only for the offender. The victim's defender is the prosecutor
Yeah.
or the crown.
Okay.
I do believe that the legal aid clinic could best serve the society as a whole if civil matters could be resolved, if they could get access to civil. Resources is going to be a problem, which is why I kind of think that with access to RJ and mediation and taking the clog out of the court, because even petty sessions court and the parish court and the things people go to court for, and the guilty with explanation and the needing to give certain persons lawyers for whatever reason, all those things, if it is not in the court, we can look to reinvent the legal aid clinic so that persons who want divorce and who want other things can access justice through the legal aid clinic. But it has to be a wholesome thing.
Yeah. I'm not fully sure that they don't. I'm not fully sure. That's the truth. I'll just leave it at that. But in answering the question, I think that what could happen to assist the legal aid in general is, one, as attorneys, and we'd have to know how to structure this, but attorneys who have been admitted to practice could perhaps be mandated to take on a certain amount of cases per year, depending on who it is. So if you have a firm, it could be that the firm has to do at least 5 legal aid cases for the year. If you're a single practitioner, maybe you do 1 or 2. And I'm just saying that, and same thing with mediation. If you're a mediator, trained mediator, you perhaps should be allowed to do at least 1 or 2 or 3 pro bono mediation cases, because that would help the clinic. We would not be the ones to decide who is to be a part of that service. Legal aid would get the matters, and then they issue them to the attorneys or the mediators. I think that would help in terms of getting civil cases in general that need to be done by persons who are less able to afford it, being done. That's what I think.
Dr. Daly?
Yes, I like Claire's suggestion. Make it mandatory for practicing attorneys to offer their services at legal aid services.
Yeah, that would be really
to the best of my knowledge, I agree with ISAT as well. I don't recall legal aid services being extended to civil matters. Of course, in more developed jurisdictions, it does, but in Jamaica, I can't recall it being extended to civil matters. How can that be done? I agree with you again, and as of course the government distributing more resources to legal aid services, because I get the impression that because it is a cost that is borne by the state, in many instances it may not get the same attention from various stakeholders. And so if the government could find ways or to provide incentives to make it attractive, certainly we can have civil matters, legal services being extended to civil matters as well.
I just real quick, the mandatory cases to attorneys, I would respectfully object to that. In the interest of the litigants.
Yeah.
And I'm gonna, and you made the point. Like I do a number of cases, and I apologize in advance. I would not do it under the umbrella of legal aid. That's just me. You want lawyers, and I would appeal to them. Certainly the ones I teach, I always say, make it your duty to give back to society. But if you don't do it willingly, you don't have an interest, there are cases that different persons will have a passion for. And so if you're given cases and you don't want to, the same thing, the spirit don't take the litigant, I'm not doing it for free. I will do it, I will help you on the basis that you need the help, I believe in you, I know you need the system, the assistance, and I'm invested in seeking justice for you. So it's a very tricky thing, save and except for I do agree that there are so many of us that we ought to take up the humanitarian aspect of it
Right.
and help your neighbor because you have the capacity.
Definitely.
Do you understand? So I'll be in court and a case comes up and it's peculiar. Like I don't think that the offender should even be in court. Whether it be a very old person or a very young person or
Right.
just somebody that looks like you just shouldn't have been there. I'll take it. That's not about the money. But we must observe that in our daily interactions and help. If we help like that, because we're putting too much pressure on government for everything, and we as a civil society, as a civilian, should do our part, which is why restorative justice is so important. If the common man does his part,
Right.
it's less work for attorneys, and attorneys don't like to hear that less work part. You know, the less need for us and less need for the officers to be coming to break up domestic abuse when they could be fighting and trying to solve murder. That kind of
Definitely.
Well, our partners, the UWI, European Union, ICS, DGov, the ERJ, this session was really entitled A Presentation on the State of Jamaica's Alternative Justice Network from the perspective of users and non-users. And we heard from our panelists. We heard Ms. Claire Miller, trained mediator, Mr. Isaac Buchanan, attorney at law, and Dr. Gavin Daly. Certainly a full panel, lots of insight is in the room, and you certainly shared with our audience online. They were robust in their expressions. Some of them some of the questions we didn't even get to ask, but we hope during the course of the discourse that some of them were answered in some way, shape, or form. Panelists, thanks so much for sharing and for coming.
Thank you.
Thank
for
you as
having
well.
us. Thank you.
Okay, and I think we moved to an early lunch. So we will be back on the other side of lunch.
Okay.
Thank you.
Thank you.
and can be resolved at the local level. So here we do the right thing and put the past behind you. Mediation is a collaborative process that encourages people to communicate freely about problems or disputes. It makes neighborhoods and towns a safer place to raise families and do business. Save money and can be resolved at the local level. So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
Me there, no man. So I'm too fuzzy.
Mama, them not have no money to bail him.
Money? See, you hear about legal aid?
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it. Yes, man. Them provide a private attorney for defend the client. Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for good on a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes. It makes neighborhoods and towns a safer place to raise families and do business. Save money and can be resolved at the local level. So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
Me there, no man. So I'm too fuzzy.
Mama, them not have no money to bail him.
Money? See, you hear about legal aid?
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it. Yes, man. Them provide a private attorney for defend the client. Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for good on a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes. It makes neighborhoods and towns a safer place to raise families and do business. Save money and can be resolved at the local level. So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
But there no man. So I'm to fuzzy.
Mama, them not have no money for bail him.
Money? See, you hear about legal aid?
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it.
Eh?
Yes, man. Them provide a private attorney for defend the client.
Eh?
Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for go down a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money.
And can be resolved at the local level.
So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
But there no man. So I'm to fuzzy.
Mama, them not have no money for bail him.
Money? See, you hear about legal aid?
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it.
Eh?
Yes, man. Them provide a private attorney for defend the client.
Eh?
Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for go down a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money.
And can be resolved at the local level.
So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
But there no man. So I'm to fuzzy.
Mama, them not have no money for bail him.
Money? See, you hear about legal aid?
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it.
Eh?
Yes, man. Them provide a private attorney for defend the client.
Eh?
Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for go down a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money.
And can be resolved at the local level. So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
But there, no man. So I'm too fuzzy.
Mama, them not have no money for bail him.
Money? See, you hear about legal aid?
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it.
Eh?
Yes, man. Them provide a private attorney for defend the client.
Eh?
Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for go down a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes. It makes neighborhoods and towns a safer place to raise families and do business. Save money and can be resolved at the local level. So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
But there, no man. So I'm too fuzzy.
Mama, them not have no money for bail him.
Money? See, you hear about legal aid?
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it.
Eh?
Yes, man. Them provide a private attorney for defend the client.
Eh?
Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for go down a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes. It makes neighborhoods and towns a safer place to raise families and do business. Save money and can be resolved at the local level. So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
But there, no man. So I'm too fuzzy.
Mama, them not have no money for bail him.
Money? See, you hear about legal aid?
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it.
Eh?
Yes, man. Them provide a private attorney for defend the client.
Eh?
Yes, man. more Jamaicans are now able to approach the court.
Alright, bro, now say a word. Now go link up mama for go down a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money
And can be resolved at the local level.
So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
But there no man. So I'm too fuzzy.
Mama, them not have no money for bail him.
Money? See, I hear about legal aid.
No, sir, what name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it.
Eh?
Yes, man. Them provide a private attorney for defend the client.
Eh?
Yes, man. More Jamaicans are now able to approach the court.
Alright, bro, now say a word. Now go link up mama for go down a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money
And can be resolved at the local level.
So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
But there no man. So I'm too fuzzy.
Mama, them not have no money for bail him.
Money? See, I hear about legal aid.
No, sir, what name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it.
Eh?
Yes, man. Them provide a private attorney for defend the client.
Eh?
Yes, man. More Jamaicans are now able to approach the court.
Alright, bro, now say a word. Now go link up mama for go down a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money
And can be resolved at the local level.
So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
But there no man. So I'm too fuzzy.
Mama, them not have no money for bail him.
Money? See, no hear about legal aid.
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it.
Eh?
Yes, man. Them provide a private attorney for defend the client.
Eh?
Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for go down a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money
And can be resolved at the local level.
So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
But there no man. So I'm too fuzzy.
Mama, them not have no money for bail him.
Money? See, no hear about legal aid.
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it.
Eh?
Yes, man. Them provide a private attorney for defend the client.
Eh?
Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for go down a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money
And can be resolved at the local level.
So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
But there no man. So I'm too fuzzy.
Mama, them not have no money for bail him.
Money? See, no hear about legal aid.
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it.
Eh?
Yes, man. Them provide a private attorney for defend the client.
Eh?
Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for go down a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money
And can be resolved at the local level.
So here we do the right thing
and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
But there ain't no man. So I'm too fuzzy.
Mama, them not have no money for bail him.
Money? See, you hear about legal aid?
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it. Yes, man. Them provide a private attorney to defend the client. Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for go down a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money
And can be resolved at the local level. So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
But there ain't no man. So I'm too fuzzy.
Mama, them not have no money for bail him.
Money? See, you hear about legal aid?
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it. Yes, man. Them provide a private attorney to defend the client. Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for go down a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money
And can be resolved at the local level. So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
But there ain't no man. So I'm too fuzzy.
Mama, them not have no money for bail him.
Money? See, you hear about legal aid?
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it. Yes, man. Them provide a private attorney to defend the client. Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for go down a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money
And can be resolved at the local level.
so here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
But there, no man. So I'm too fuzzy.
Mama, them not have no money for bail him.
Money? See, you hear about legal aid?
No, sir, what name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it. Yes, man. Them provide a private attorney for defend the client. Yes, man. More Jamaicans are now able to approach the court.
Alright, bro, now say a word. Now go link up mama for go down a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money
And can be resolved at the local level.
so here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
But there, no man. So I'm too fuzzy.
Mama, them not have no money for bail him.
Money? See, you hear about legal aid?
No, sir, what name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it. Yes, man. Them provide a private attorney for defend the client. Yes, man. More Jamaicans are now able to approach the court.
Alright, bro, now say a word. Now go link up mama for go down a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money
And can be resolved at the local level.
so here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
But there, no man. So I'm to fuzzy.
Mama, them not have no money to bail him.
Money? See, you hear about legal aid?
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it. Yes, man. Them provide a private attorney to defend the client. Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for go down a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money
And can be resolved at the local level. So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
But there, no man. So I'm to fuzzy.
Mama, them not have no money to bail him.
Money? See, you hear about legal aid?
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it. Yes, man. Them provide a private attorney to defend the client. Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for go down a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money
And can be resolved at the local level. So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
But there, no man. So I'm to fuzzy.
Mama, them not have no money to bail him.
Money? See, you hear about legal aid?
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it. Yes, man. Them provide a private attorney to defend the client. Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for go down a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money
And can be resolved at the local level. So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
But there, no man. So I'm to fuzzy.
Mama, them not have no money for bail him.
Money? See, no hear about legal aid.
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it. Yes, man. Them provide a private attorney for defend the client. Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for good on a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money
And can be resolved at the local level. So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
But there, no man. So I'm to fuzzy.
Mama, them not have no money for bail him.
Money? See, no hear about legal aid.
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it. Yes, man. Them provide a private attorney for defend the client. Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for good on a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money
And can be resolved at the local level. So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
But there, no man. So I'm to fuzzy.
Mama, them not have no money for bail him.
Money? See, no hear about legal aid.
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it. Yes, man. Them provide a private attorney for defend the client. Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for good on a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money
And can be resolved at the local level.
So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
But there ain't no man. So I'm too fuzzy.
Mama, them not have no money for bail him.
Money? See, no hear about legal aid.
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it. Yes, man. Them provide a private attorney for defend the client. Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for go down a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money
And can be resolved at the local level.
So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
But there ain't no man. So I'm too fuzzy.
Mama, them not have no money for bail him.
Money? See, no hear about legal aid.
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it. Yes, man. Them provide a private attorney for defend the client. Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for go down a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money
And can be resolved at the local level.
So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
But there ain't no man. So I'm too fuzzy.
Mama, them not have no money for bail him.
Money? See, you hear about legal aid?
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it. Yes, man. Them provide a private attorney for defend the client. Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for go down a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money
And can be resolved at the local level. So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
But there, no man. So I'm too fuzzy.
Mama, them not have no money for bail him.
Money? See, you hear about legal aid?
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it. Yes, man. Them provide a private attorney for defend the client. Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for go down a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money
And can be resolved at the local level. So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
But there, no man. So I'm too fuzzy.
Mama, them not have no money for bail him.
Money? See, you hear about legal aid?
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it. Yes, man. Them provide a private attorney for defend the client. Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for go down a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money
And can be resolved at the local level. So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
But there ain't no man. So I'm too fuzzy.
Mama, them not have no money for bail him.
Money? Say no hear about legal aid.
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it. Yes, man. Them provide a private attorney for defend the client. Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for go down a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money
And can be resolved at the local level. So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
But there ain't no man. So I'm too fuzzy.
Mama, them not have no money for bail him.
Money? Say no hear about legal aid.
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it. Yes, man. Them provide a private attorney for defend the client. Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for go down a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money
And can be resolved at the local level. So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
But there ain't no man. So I'm too fuzzy.
Mama, them not have no money for bail him.
Money? Say no hear about legal aid.
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it. Yes, man. Them provide a private attorney for defend the client. Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for go down a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money
And can be resolved at the local level.
So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
But there, no man. So I'm too fuzzy.
Mama, them not have no money for bail him.
Money? See, you hear about legal aid?
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it. Yes, man. Them provide a private attorney for defend the client. Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for go down a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money
And can be resolved at the local level.
So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
But there, no man. So I'm too fuzzy.
Mama, them not have no money for bail him.
Money? See, you hear about legal aid?
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it. Yes, man. Them provide a private attorney for defend the client. Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for go down a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money
And can be resolved at the local level.
So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
But there, no man. So I'm too fuzzy.
Mama, them not have no money for bail him.
Money? See, you hear about legal aid?
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it. Yes, man. Them provide a private attorney for defend the client. Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for go down a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money
And can be resolved at the local level. So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
But there, no man. So I'm too fuzzy.
Mama, them not have no money for bail him.
Money? Say no hear about legal aid.
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it. Yes, man. Them provide a private attorney for defend the client. Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for go down a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money
And can be resolved at the local level. So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
But there, no man. So I'm too fuzzy.
Mama, them not have no money for bail him.
Money? Say no hear about legal aid.
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it. Yes, man. Them provide a private attorney for defend the client. Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for go down a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money
And can be resolved at the local level. So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
Me there, no man. So I'm too fuzzy.
Mama, them not have no money for bail him.
Money? See, no hear about legal aid.
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it.
Eh?
Yes, man. Them provide a private attorney for defend the client.
Eh?
Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for go down a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money
And can be resolved at the local level.
So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
Me there, no man. So I'm too fuzzy.
Mama, them not have no money for bail him.
Money? See, no hear about legal aid.
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it.
Eh?
Yes, man. Them provide a private attorney for defend the client.
Eh?
Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for go down a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money
And can be resolved at the local level.
So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
Me there, no man. So I'm too fuzzy.
Mama, them not have no money for bail him.
Money? See, no hear about legal aid.
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it.
Eh?
Yes, man. Them provide a private attorney for defend the client.
Eh?
Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for go down a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money
And can be resolved at the local level.
So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
But there ain't no man. So I'm too fuzzy.
Mama, them not have no money for bail him.
Money? See, you hear about legal aid?
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it. Yes, man. Them provide a private attorney for defend the client. Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for go down a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money
And can be resolved at the local level.
So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
But there ain't no man. So I'm too fuzzy.
Mama, them not have no money for bail him.
Money? See, you hear about legal aid?
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it. Yes, man. Them provide a private attorney for defend the client. Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for go down a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money
And can be resolved at the local level.
So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
But there ain't no man. So I'm too fuzzy.
Mama, them not have no money for bail him.
Money? See, you hear about legal aid?
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it. Yes, man. Them provide a private attorney for defend the client. Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for good on a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money
And can be resolved at the local level. So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
But there ain't no man. So I'm to fuzzy.
Mama, them not have no money for bail him.
Money? Still hear about legal aid.
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it. Yes, man. Them provide a private attorney for defend the client. Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for good on a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money
And can be resolved at the local level. So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
But there ain't no man. So I'm to fuzzy.
Mama, them not have no money for bail him.
Money? Still hear about legal aid.
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it. Yes, man. Them provide a private attorney for defend the client. Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for good on a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money
And can be resolved at the local level. So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
Me there, no man. So I'm too fuzzy.
Mama, them not have no money for bail him.
Money? See, you hear about legal aid?
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it. Yes, man. Them provide a private attorney to defend the client. Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for go down a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money
And can be resolved at the local level. So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
Me there, no man. So I'm too fuzzy.
Mama, them not have no money for bail him.
Money? See, you hear about legal aid?
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it. Yes, man. Them provide a private attorney to defend the client. Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for go down a legal aid council.
Mediation is a collaborative process that encourages people to communicate freely about problems or disputes.
It makes neighborhoods and towns a safer place to raise families and do business.
Save money
And can be resolved at the local level. So here we do the right thing and put the past behind you.
Restorative justice gives victims the opportunity to communicate with the offender. It is not about passing judgments, but repairing harm that has been done. Restorative justice works. Yes, everyone has the ability to change. Restorative justice, a pathway to a more secure Jamaica.
What go on, bro, God?
Me there, no man. So I'm too fuzzy.
Mama, them not have no money for bail him.
Money? See, you hear about legal aid?
No, sir. What name, sir?
Everyone has the right to justice in the country's justice system, even if them can't afford it. Yes, man. Them provide a private attorney to defend the client. Yes, man. More Jamaicans are now able to approach the court.
Alright, bro. Now say a word. Now go link up mama for go down a legal aid council.
2. Welcome back, and I hope you all had a very interesting break. You were able to get yourselves refreshed and ready for the next segment to come. This is the UWI EU Alternative Justice Initiative, and you're at the closing ceremony. And as we said before earlier today, it's the culmination of 24 months of hard work on the part of these two actors. And we spoke earlier to the different pronged approach involved in this outfit, right? So we talked about a space for alternative justice actors to share. We looked at a social behavioral change aspect, but we also spoke to a strategic and legal framework of alternative justice, right? And so this next presentation is going to be focused, intentionally so, on that aspect of the approach that we spoke about. So the presenter is Mr. Michael Williams, and he's an attorney at law. The presentation he's going to make is on the legislative review of Jamaica's alternative dispute resolution framework. So please make him welcome, Mr. Michael Williams.
All right, thank you very much, Roger, for that introduction. It's actually quite interesting because Roger and I have a history where he is instrumental to me becoming an attorney as someone who was my coach while I was a debater at the University of the West Indies. And now it turns around that he's here to see the results of that coaching with me making this presentation. Now, as Roger says, this is really a presentation of what the legislative framework is like in relation to alternative dispute resolution in Jamaica. Where I'd like to start is where we look first at the conclusions, and then I'm going to go through and explain how those conclusions were arrived at. So, undoubtedly, Jamaica, like the rest of the world, in terms of its judiciary, faces a number of issues, and in particular, we have now a very strong sense of what those issues are. Firstly, there's the issue of delays. Our judicial system is plagued with delays. It has been said ad nauseum in all forms of public spaces about the delays which affect the judiciary. And mediation, based on the findings of this entire project, may contribute in the way that it is framed to some of the delays that are being meted out to persons and court users. The second issue that we have is, or we found rather, is that there is a lack of statutory jurisdiction and support for alternative dispute resolution as it forms part of the judicial framework. Meaning, we have a system in Jamaica where mediation is automatic. And for those who were here earlier, Claire Miller indicated that she had a particular view, which is that instead of mediation becoming an automatic referral after a matter has been filed in court, there should be the alternative where you go to mediation before the matter is filed. So that gives us a little idea of that particular framework where mediation in Jamaica, as far as Supreme Court matters are concerned in the civil jurisdiction, those matters are automatic. And I use the word automatic, but really it's mandatory in certain circumstances. Then there is also the issue of capacity. So it is also well documented in the Jamaican experience that there are more matters which are being filed in the Supreme Court in terms of civil matters. And even in the criminal courts, there are more criminal matters that are going before the courts. So the question is, when we consider the exponential increase of court users who are petitioning to the court, do we have the capacity, especially under automatic referral to mediation, for us to accommodate and to deal efficiently with these increased court users? The other finding that we found, and that's redundant, but we have certain fees which are associated with this mandatory mediation in the Supreme Court. So even though everyone who files a claim in a particular court, meaning civil courts, where there is no dispute as to fact, that isn't automatically referred. However, where there are disputes as to fact, and I'll go into this more, there are fees which are associated with going to mediation, which must be paid by the court user. So we will look at that as well to see how much of a bulwark that may be to accessing justice for many indigent and poor court users. There is also a question about whether or not there is sufficient information in the public space about mediation. Mediation in the sense of, do people know what it is? Are people cognizant that it is mandatory? Are people aware of the fees that are associated with it? And even more on the technical side, what is the efficiency? What is the outcome? What is the statistical history of mediation, and how does that inform court users as to how to mediate, how to be more effective in mediation, and how to resolve disputes in that way? There is also the question, and there are many questions actually, but the way that Jamaica's Alternative Dispute Resolution Foundation, which is the primary source of mediation referrals from the Supreme Court, is set up, it effectively has a monopoly on court-ordered mediation. And there is a question which arises from that because, you know, the saying and the rule of thumb or the thought is that where you don't have competition, you create a breeding ground for mediocrity. That's not to say that the DRF is not having results, but it's the findings that we found, again redundant, but nonetheless, the findings are that the rate at which matters which are referred to the Dispute Resolution Foundation under automatic referral to mediation under the Supreme Court jurisdiction is actually extremely low. And because of that, there is the potential that because there is only one agency and lack of competition, there isn't much push for mediations to be more successful. And finally, which is the sixth key recommendation and finding, is that there is no real means of checking and balancing what happens in mediation, what happens between the mediator and the persons who are engaged in the mediation. And there really is no recourse for someone who feels aggrieved by what happens under mediation. So that is the general overall picture, and I think we can safely go through them. It will take a while because this has been perhaps one of the more extensive areas of this, but I believe that we can get through it quickly. So let us start first with the issue of delays. One of the greatest things about our judiciary in the most recent years is the publication of certain statistics regarding the judiciary. So it started with our former Chief Justice, the Honorable Mrs. Justice Zelia McCalla, and continues with our current Chief Justice, the Honorable Mr. Justice Brian Sykes. And what it does, it creates an idea of court users, case numbers, and the ways in which we are disposing of those cases. So we are thankful that we were able to extrapolate from these statistical reports the numbers which really have indicated over progressive years as trial date certainty improves, the delays and the length of matters from inception to end has increased. So, in 2017, for instance, there were approximately 4,396 new cases filed in the civil court of the Supreme Court, and the average time of disposal for matters was about 2 years and 9 months. In 2018, the new cases increased to 5,077, but the average time for disposal increased to a maximum, or on average, of 3 years. Then we saw in the statistics which came out in 2019, we had at the time access to 2 terms of the 3-term period for the year for 2019. And when we looked at both terms, the average time of disposal of cases continued to increase from a high in 2018 of 3 years to 3 years, 3.36 years at the first term of 2019, and then 4.2 years in the second term of 2019. So we took the inference that unless there was some serious case disposals within the third term of 2019, then on average, the time for disposing of a matter was looking closer to 4 to 5 years for disposal. And those statistics have come out, and it confirms that indeed it's now at an average of over 4 years for the disposal of matters. So what this means, in plain terms, is from the moment you file a claim in the Supreme Court in the civil jurisdiction, between the time of filing to the date of being heard at a trial, takes anywhere from, on average, takes about 4 years, and it continues to grow based on the trends on the statistics. So we, with our inquisitive mind, decided to review how mediation has impacted on 2 things. One, the time for completion of matters in terms of getting a judgment and getting the matter removed from out of the active courts list. And secondly, whether where you fail to come to some kind of agreement at mediation, then whether or not that failure period contributes in a significant way to the delays in getting towards your judgment. And some of the things that we found, which were possible reasons for why there has been such a constant increase since 2017 to now, are a number of reasons. We have had, for instance, a very vocal Chief Justice, the Honorable Mr. Justice Brian Suggs, who has pushed towards publicly improving the efficiency of the court system. And he has been pushing for what is currently termed trial date certainty, which means that it measures the extent to which the public can say with certainty that when their matter is set for trial, it is certain to go on or to be heard on that date. So with that in mind, we found that with the push towards trial date certainty, there seems to be an added pressure for judges and for the administrators of court to ensure that when a matter is set for trial, it is set because the parties are ready to go to trial, meaning there are no outstanding issues in terms of preparation that is required. So that was one of the reasons that we thought judges are now more reluctant to set matters, judges and court administrators are more reluctant to set matters for trial unless they are sure that the matters are, as opposed to will be ready for trial. So that may contribute, one, to the delays in the judicial system. Judges are more careful because of that. So they are going to be scrutinizing and ensuring that anything that could go wrong is accounted for before setting a matter for trial. Now, the other issue that we found, which is also well documented, is the backlog. So judges have no real flexibility with setting matters for trial because they are accounting for the backlog of cases. So because we have so many increased numbers of cases and because we have so many matters that need to be disposed of, the period and the available slots have been pushed further away, and thus that may also account for the delays in matters coming to completion. And what we found as well was that automatic mediation or referral to mediation in itself is a scheme which increases the timeline for the completion of matters. So we're going to zoom in currently as to how this automatic referral of mediation currently works. So in the Supreme Court, there is what we call regular claim form proceedings and fixed date claim form proceedings. Automatic mediation only occurs with regular claim form proceedings. What does this mean? Regular claim form proceedings are those kinds of proceedings where there are substantial disputes as to fact, where there's going to be extensive cross-examination of witnesses, where there is going to be the need for the judge to say who he or she believes, which version of events they believe, and it's not strictly confined to a matter of law or simple questions of fact. And that is substantially where we have a number of cases that are coming in to the Supreme Court. So in those kinds of cases, those are the matters where where the claim form proceedings must be referred to mediation. Now, here is the timeline. When you file a claim in the Supreme Court, you have a 6-month period from the filing of the claim for you to serve the claim on the other side. So if it's not served within these 6 months, it would no longer be valid and you would have to refile a new claim. So we have that aspect of it clear. If, however, you as the claimant, the person who files the claim, realizes that there is the potential that you will not be able to serve it, the claim form, within that 6-month period, you have the option of applying to the court for the court to extend the life of the claim for an additional 6 months. However, you can only do this 2 times on 2 separate applications. So what this means is after the initial 6 months of service, there's the potential that you might have another year for the claim form to be served. So that's 1 year and 6 months where potentially nothing can happen further in the claim until it is served. So that accounts potentially for an entire year and year and a half for the claim form to be served. But that's not just the only delay before you can actually go before a judge. The other delay is that the defendant, or the person who is served, now has to do certain things and they require a certain time. So from they have been served with the documents, they have 14 days to file what's called an acknowledgement of service, which says, I received these documents on this day and I either will admit to everything or I will defend everything. And that happens 14 days after it has been served. Then, from the date of service, in addition to filing that acknowledgement of service, they must file a defense within 42 days of service. So essentially, that is a month and a few weeks, if my math is correct, maybe a week. So it's an additional timeline that is there for you to, before you can actually go before a judge. So we are looking at an additional timeline of over a year and a half before you can be heard by a judge. Then there is the option that once I, as the claimant, am served with that claim document, with the defense rather, I can reply to it by filing a document called a reply within 14 days of receiving that defense. So it's clear that there is a long time before you can actually go before a judge potentially. ranging from a year to perhaps a year and a half or more. And then it is at this stage where you filed your reply to defense if required, or if not required, after the defense has been filed within the 42 days, that you are automatically referred to mediation. However, this mediation process and this automatic referral process isn't very strict, we found, in terms of the timeline. Because, as has been said before, mediation is essentially a voluntary process. And essentially, this is recognized to the extent that the parties must agree on the time, must agree on the date, must agree on the mediator. So that period of the parties trying to come to some consensus as to find the right calendar date, to find the right mediator, to make sure the dates selected by the parties are available for the mediator, and that process can take an additional 3 months or more. In very rare occasions, we have seen where it's gone on a year or 2 years after it should have been concluded. So there is a lot of moving parts involved with this automatic referral to mediation, which we have found has contributed to some of the delays that are currently in place. It is only after you have concretized those arrangements, gone to the mediator, paid your fee of $12,500 per party, meaning claimant has to pay $12,500, and the defendant, if represented by multiple defendants, if represented by the same attorney, will only pay $12,500 for the entire parties that are represented by the same attorney. So that's an additional cost in addition to time that we found is intertwined in the mediation process. But after all of that is completed, after you've gone to mediation and say you have actually concluded on some kind of compromise, then essentially you would have skipped out the entire period of case management and pre-trial review and all necessary things to put you on the trial list, because you would then apply to the court to make the agreement that was reached between the parties an order of the court. So there wouldn't be a trial, there wouldn't be the need for case management, and there wouldn't be the need for you to go before a court or the judge except to concretize what has been agreed in mediation. However, the frequency at which this occurs in terms of parties coming to a compromise is so low that what happens is that the parties would just have, I don't want to say wasted, but they have used up about a year or a year and a half to 2 years where they have not been before the court and where a date for the trial has not been set. And that is the reality overall of how the system or the framework of our mediation process in Jamaica operates. Now, there are specific findings which we have to bring to your attention. The first finding was in relation to the frequency with which parties have applied to the court to dispense with mediation. So, as with law, for every rule there is an exception. And so there is the provisions which are under our rules which parties can apply to the court to ask that mediation, which is usually mandatory, be dispensed with, meaning you don't have to do it. That accounts for between the second and third highest applications that have been made to the Supreme Court between 2017 to 2019. Now, these applications are either granted or denied, or there might be some provisional arrangement in place. However, we found that the mere fact that you have to make these applications to the court, when the time that the court uses to either grant, refuse, or make some alternative arrangement in relation to mediation, that time could have been spent on other matters of case management. So let me just find the statistics. Crave your indulgence. Well, the statistics indicate that, as I said, the third highest, between the second and third highest applications to the court have been for applications to dispense with mediation. But before that, speaking specifically to the statistical reports for the year of 2017, it indicated that there were 1,063 cases disposed of in that year. But of those 1,063 cases, only 10 were disposed of at mediation, which speaks to the low frequency with which matters which have gone to referrals for mediation have been successfully completed with a concluded mediation agreement. In addition to those 10 which were completed at mediation, 3 were fully settled in mediation. I'm not sure what the distinction is, but this is what the statistics provided by the court indicates. But overall, we've accepted that that would mean 13 cases of the 1,063 which were referred to mediation in 2017 were disposed of at the mediation stage. What we also found interesting, however, was that in 2017, there were 201 cases which were indicated as being settled in the court system outside of mediation. 2 resulted in settlement orders, and 77 notices of discontinuances were filed. What this means is, even after they've went to mediation, or gone to mediation rather, 201 cases were settled or announced to the court as settled. Then there were 2 which resulted in orders of the court detailing how the settlements were to operate, and there were 77 notices of discontinuance. Now, notices of discontinuance is where the claimant indicates to the court that I am withdrawing this claim. It doesn't indicate to the court the reasons for the withdrawal. However, it does, in the grand scheme of things, indicate that there is some propensity for us as court users to come to some compromise. However, we found that those compromises occurred outside of the formal mediation arrangement in the majority. So the statistical reports continued for the year 2018, where it indicated that 1,692 cases for that year were being dealt with. Only 7 of those numbers were completed at mediation, and it also indicates that 11 were settled fully in mediation. So taking that total, there would have been at least 18 cases which were settled at the mediation stage. But outside of mediation, there were 243 cases which were recorded as settled. There were 309 matters discontinued, and again, it's not unreasonable for us to assume that these discontinuances included some arrangements through informal, for want of a better word, mediation. So again, the frequency continued in 2018 to indicate that there were lesser numbers of settlements and discontinuances coming out of formal mediation arrangements. However, outside of mediation, they clearly indicated a higher propensity for settlement. Now, for the first term of 2019, we have the statistics that says of the 338 matters disposed of, only 5 were settled fully in mediation, and 32 were settled outside of mediation, and 201 cases were discontinued. So we saw that this continued in terms of a trend where the frequency of mediation settlements within the formal arrangements were low, while the arrangements for settlement outside of mediation in the formal court system were higher. And then in the second term, one matter was recorded as fully settled at mediation, one matter settled outside, and 10 notices of discontinuances were filed for the 156 cases. So that is essentially 11 matters of the 12 rather of the 156 cases disposed of in the second term of 2019. So it is an inescapable inference for us from these statistics that it does not appear that there are high enough instances of mediation resolved disputes for there to be any significant indication that automatic referral to mediation results in early resolutions of matters. However, our proviso and our limitation is that the statistics may not be sufficient empiricism to be conclusive due to the short periods under review. So 2017 to 2019 is admittedly a low number of terms or years for us to say conclusively that this is a trend that is something which we say is causative as opposed to correlative. So that is one of the issues that we found, that statistically the frequency with which matters are disposed of because of automatic or out of automatic referral to mediation is not of a sufficiently high number for it to as opposed to the parties going through the normal court system and coming to some kind of settlement outside of mediation. So that was one of the major issues, and because of that we had the finding thus far that it appears that the way in which we have made mediation mandatory in our jurisdiction has not met the initial objective, which is reducing the number of matters that are filtering into the formal court system and reducing the time by which these kinds of matters can be disposed of. So that was the first red flag, that it is contributing to the delays in the justice system in Jamaica, contributing to the longer wait times for trial judgments because of the low frequency with which mediation in the formal court system has presented results of full settlements in mediation. We also found on the flip side that court users are not opposed per se to settlements in the court system. It appears though that they are more inclined to settle outside of mediation than within mediation. And so we considered what could be some of the reasons for this high frequency of settlement outside of mediation, but the low frequency of settlements within mediation. Now, one of the things that we think contributes to a high instance of non-performance at mediation is the cost factor. I know I had said earlier that the cost was $12,500. However, that is the old cost. That cost now has doubled to, not doubled either, but it is $25,000. So it's $25,000 per party to attend mediation. What does this mean? It means that this is a cost that is immediately payable by court users who are referred automatically to mediation. There is the initial cost of $5,000 stamp duty to file your claim in the Supreme Court if you're a claimant, but the defendant who is brought to court doesn't have to pay that $5,000. However, when you're going to mediation, that's an additional $25,000 for the claimant and a $25,000 fee for the defendant. And if they're separate defendants represented by separate attorneys, That's $25,000 each. So, using the example of the one claimant, one defendant, that is in total $50,000 that is required for that mediation exercise to go through. We found that this may impact the perception of court users when attending and going to mediation. Because when you pay, we found, for this service, you are now inclined to get your money's worth. So you are more likely to view the automatic / mandatory referral to mediation as an entitlement where you should get your money's worth, as opposed to coming to a compromise. So that, we thought, was one of the ways in which the perception of court users may be affected by automatic referral to mediation, which has a low frequency of resolution of matters in that particular program. So we found that this was a bulwark to not only compromising, but also for poor and indigent persons to access the courts. So it means now that, for instance, I as a claimant decide that I'm going to file a frivolous claim against the defendant who is not a person of means. The fact that we are now required to attend mediation and required to pay that $25,000 per party to the mediation referral agency, which is the Dispute Resolution Foundation in most cases, it means that if I'm unable to afford that $25,000 from my disposable income because I am brought as a defendant to the court, that means that that also may contribute to some delays where I'm required to go and find and secure that money, or it may simply mean that my ability to defend myself is delayed, or I simply just cannot do it. So that was one of the issues as well that we saw in relation to timelines for completion. This cost factor, which in the case of a defendant, for instance, is not something that is budgeted for or anticipated, can result in further delays while the parties are trying to come up with the money and trying to agree to the mediator and are trying to agree to the dates. So we saw this $25,000 price tag attached to it. One of the reasons that court users' perception of mediation might be skewed away from some kind of compromise, since these kinds of hardships could result in their mindset while they're attending mediation. So the other thing is that this $25,000 per party might, as we said, actually be one of the main reasons why applications to dispense with mediation are so frequent, because there is the possibility that a party simply cannot afford this mandatory $25,000, and as a result they may have to apply to the court to dispense with it, and this may actually increase the frequency of these applications, and it may increase the timelines or the use of the resources of the court, so that trial dates are moved and pushed further away. So that was also a significant factor that we saw in relation to the system and framework of mediation in Jamaica. And we were of the view that conclusively this cost factor acts as a bulwark to accessing justice and to the efficiency with which mediation results in a compromise and reduces the backlog and reduces the stress on the courts. So that was another issue. But we went a little deeper in terms of our analysis, looking outside of these statistical reports and more towards the legislative framework. Now, we discovered a deeper analysis, an anomaly, for want of a better word, as to how the arrangement with automatic referral of mediation occurred in Jamaica. So for this purpose, I will refer to a specific case that was decided in relation to a provision of Jamaica's civil procedure rules regarding what we call charging orders. So we had in Jamaica, and we do have in Jamaica, the civil procedure rules which governs how civil arrangements in terms of court actions are to proceed. There was a provision in the civil procedure rules which is what we call subsidiary legislation. It is a document which gets its power from another document or other documents which are the laws of Jamaica. So we have, for instance, the Judicature Supreme Court Act, and we have the Judicature Rules of Court Act. The Rules of Court Act empowers a committee to create these rules, and these rules are only to provide guidelines, and in some terms mandatory guidelines for how the powers of the court may be exercised. In relation to the charging orders, there was a provision under our rules which made the procedure for charging a property for unpaid debt. So for instance, the classical example is, I've taken you to court for you to pay me some money you owe me. We've gone to trial. I received a judgment which says that you are to pay me $1 for example's sake. You have not paid the $1, but you have a property that is registered in your name that is valued at $1. And so I make an application to the court for me to put a charge over your property for that $1, so that eventually, if you're unable to pay me, I can then make an order or request an order for the sale of that property to recover my $1. That matter had gone to court, and someone had made an application to charge property. However, as far as high up as the Privy Council found, that while it is that the rules had those provisions relating to the charging orders, the Judicature Supreme Court Act, which is the foundation of the Supreme Court, never made any provision for the charging of property. So what was found was that the rules could not create a jurisdiction for the court where that jurisdiction was not already provided for in the primary legislation. So we looked at that case and we considered the implications of it on mediation. Now we have looked through the Judicature Supreme Court Act and all the acts which relate to the powers of the Supreme Court, and we could not find any provision or amendment to that primary legislation which made provisions for automatic referral to mediation. What does this mean? This means that potentially or arguably the entire scheme by which we mandate and require parties to attend mediation and have to apply to the court to remove that or dispense with that requirement is technically a provision which creates a jurisdiction for mediation, where the Judicature Supreme Court Act, the primary legislation, does not provide for it. So it's a question which is raised as to whether or not the automatic scheme of it is constitutional or is provided for under our local legislation. We have looked at the cases, we have looked at the legislation, and unfortunately we have not found a provision which makes this automatic referral a scheme which is grounded in the Judicature Supreme Court Act. The result of this is, if there is to be a serious challenge to the scheme, there might be the potential repetition with charging orders, where that without some amendment to the Judicature Supreme Court Act, which makes the referral automatic, because it creates a jurisdiction for the Dispute Resolution Foundation or the mediation referral agency, it creates a jurisdiction for them which takes you out of the court system into this mediation session, and if successful, that would be the end of the matter, save and except the court may make the order in terms of what was agreed. But if it does not, then you remove yourself from the jurisdiction of the Dispute Resolution Foundation, the mediation, and go back to the Supreme Court. So essentially we found that that was what was being created by automatic referral to mediation. And we were of the view that unless there is some kind of legislative amendment, this question remains a valid one, and in fact, by all indications, it could be that this scheme could not be legally upheld if seriously challenged in the court. So that was something that we found to be a little questionable in terms of the legislative framework. And we found this troubling because of the way in which mediation is set up. Now, you would have heard from previous presenters and from the panel discussion that what happens in mediation is something which does not go back to court. It is private, it cannot be repeated outside of the mediation session, and it is confidential and privileged. Now, this has been enforced by the courts in several ways. In fact, there are recent decisions which says that even if the parties after mediation have some ambiguity in the orders or in the direction that the agreement arrived at mediation could change or evolve or not have been concluded, when the report from the mediation is sent to the Supreme Court, even if one party objects or has some recommendation or wants a change in the mediation report, the court does not change what is written down on paper in mediation, in that mediation report. So, to give you the example of a specific case, in this case, husband and wife had gone to mediation in terms of division of matrimonial and non-matrimonial property, meaning property other than the family home. The parties had gone to mediation, come to some compromise in terms of some of the properties, and there were additional properties which were not, there was no consent in relation to. The mediator sent a report with what was concluded, and there was the remaining questions as to what is to occur with the other properties. That report was sent to the court to be converted into an order as required under the provision of our rules. One of the parties, the husband or ex-husband, he was not present on the day that the order was converted by the court into, the agreement was converted to an order of the court. And so what transpired was the court made an order based on the terms of the mediation agreement in the absence of one of the parties and one of the parties' lawyer. When the husband / ex-husband found out about it, he applied to the court for the order to be varied to other terms and to reflect that there were certain terms of the consent order which were incomplete. It went before a certain judge, and the judge was of the view that she could not hear the application, and the application was refused. That meant that there now was the requirement for an appeal to the Court of Appeal in relation to whether or not the court had the power to vary the terms of the agreement to account for those outstanding issues. And in a 2-1 decision, the Court of Appeal was of the view that there was no flexibility, no jurisdiction for the judge or for the court to do anything other than accept what came out of mediation and out of that mediation convert that to an order. So what does that mean? It means that whatever happens in mediation, the court has no regard for it. The only thing that the court has regard to is whether or not an agreement came out of the mediation, and the court was duty bound to convert the letter and terms of that agreement into an order of the court. And that was how we realized that the court's overall view of mediation is. It is unconcerned with what is the privileged information there. It is unconcerned with the discussions that transpired there. But then we did a little bit more digging, and there was also a very interesting case where a party tried to get a mediator to come to court to give evidence about the conduct of another litigant in the mediation process. And it was a very public matter involving politicians in Jamaica. So one of the parties had got what we call a judgment summons, which is requiring the mediator to come to court to give evidence. The mediator being served with this summons applied to the court to set it aside, to say that it is of no moment, it should not be granted, it should never have been granted for her to come to the court to answer questions. And the court agreed with her. Court found that she could not be asked, and no mediator could be asked to attend court to give evidence as to what transpired in mediation. There could be no question posed to her about the conduct of the parties in the mediation, what was discussed in the mediation, or anything other than whether or not an agreement was made. And in any event, that report would have been filed, so it's not required for the mediator to go to court to discuss or to say anything in relation to what transpired in mediation. And interestingly, the judge found that it was a misnomer for there to be mandatory referral to mediation, since mediation is by its very definition a voluntary process. But that was not really the issue before her, so the judge simply left it at that. But that is just to indicate to you the extent to which we found that the way in which automatic referral of mediation is set up in Jamaica, it creates its own scheme, it creates its own jurisdiction for mediators, where they cannot be compelled to give evidence in the court, where they cannot be asked any question, and what they have written in their report, which is signed admittedly by the parties, that is what is converted into an order of the court without question. So that again reiterates why the idea of whether or not this scheme creates a jurisdiction for mediation where none existed before is one which is fresh and poignant in terms of our minds. So with that in mind, we decided where to look to see how mediation is dealt with in the way that does away with these problems that we've seen in the Jamaican experience. We have looked at the United Kingdom, for instance, because the entire scheme of, say, the civil procedure rules, which was to make the court process just, fast, inexpensive, and consistent for civil litigants, was something we extrapolated and continued from the United Kingdom's approach to the civil procedure there. So the first thing that we found, and this is perhaps useful for Jamaica, is that the UK does not make mediation automatic. The parties must opt to attend mediation by indicating on a questionnaire which is submitted to the court whether or not they want to go to mediation. And so the approach of a court has been well documented, and they have a civil court mediation service management manual rather, which explains the process to judges and to court users. So under our rules, for instance, there is the court's duty to actively promote the use of mediation, and it specifically says mediation, whereas in the United Kingdom it says alternative dispute resolution without reference to mediation. But we know that Jamaica has a particular preference for mediation in the scheme that it has created. So one of the things that we found useful under the Civil Court Mediation Service Manual of the UK was that they had certain criteria before making a decision that a matter should go to mediation with the consent of the parties. So one of the things they say is they look towards the nature of the dispute, as to which the court warned that, quote, most cases are not by their very nature unsuitable for mediation. 2, the merits of the case, by which a party which reasonably believes it has a strong case might be justified in proceeding to litigation, which I think is the scenario that we have in Jamaica. 3, other settlement methods have been attempted, and though the court noted that, quote unquote, mediation often succeeds where other settlement attempts have failed. So, and that's the end of that quote. But what we found in the UK is that there is pre-litigation protocol, where there is discussion, the writing of letters, the attempt at some compromise before a claim is filed, whereas in our jurisdiction, pre-litigation protocols do not appear to, do not appear, they simply aren't part of the rules. We do have the courtesies which attorneys extend to each other, but it is not a requirement under our rules. The fourth view was, or reason by the UK courts, is cost of mediation would be disproportionately high. So this is a question that varies a little differently from our jurisdiction. In our jurisdiction, the price is set at $25,000. In the UK's jurisdiction, because there is no monopoly on mediation referrals, then different agencies will charge different fees. And because of that, there might not be consistency with fees across the board. So that question, though relevant to our jurisdiction and to our situation, is a little different from the United Kingdom's perspective. The fifth criteria was delay to a trial date. And so the UK system, before deciding whether or not parties or cases are fit for mediation, must consider whether or not it is worth the delay. In our jurisdiction, that criteria is not something which is actively engaged, because all mediation in claim form proceedings, as opposed to fixed date claim form proceedings, are mandatory. There is no discretion. So the delay to trial date is not something that is actively considered by the litigants, the court users, and by the court itself. And the final criteria is whether mediation had a reasonable prospect of success. Now for this, the burden of showing whether or not mediation has a reasonable prospect of success lies with the unsuccessful party who proposed mediation, and not with the successful party who refused. What this means is it's more of a hindsight criteria, where afterwards the court will question whether or not it was reasonable for the parties to have refused to mediate at an earlier stage, and whether it is relevant now for the parties to go and mediate. Now this stands in contrast with Jamaica, because all of these criteria, except for the last one, which is about the reasonable prospect of success, are the criteria that have been applied to dispense with mediation. So after the parties have gone through the attempts at mediation and have not been able to go, the criteria which is provided for under our civil procedure rules is that you consider, for instance, the merits of the case, the nature of the dispute, the attempts to mediate outside of mediation, which have been unsuccessful. And so whereas Jamaica's civil procedure rules require us to look at these things after the fact, the court in the United Kingdom looks at it before a party or parties are referred to mediation. So it would appear that the criteria that you used in the UK to refer a matter to mediation is the criteria used in Jamaica to dispense with mediation to an extent. It appears that the manner in which the UK applies to determine whether or not to send a party to mediation does not create the problems which appear in our rules under the applications to dispense. So we've reached now the criteria which the court employs for applications to dispense. We've looked at the cases where what happens in mediation is confidential, it's private, the mediator cannot be compelled to give evidence. But say, for instance, the parties have gone to mediation, are to continue mediation, but one of the parties has decided, for whatever reason, to not make themselves available. The application to dispense with mediation and the criteria required by the court borders or, in fact, skirts around the issue of confidentiality, in the sense that if there is an active contested application to dispense with mediation where parties say, no, I am cooperating, it is the other side that is not cooperating, or the other side says it's the other side that's not cooperating, how then can the court investigate those claims without going into what transpired in court? I suppose the simple answer is, once there is that kind of dispute, it is perfectly fine for the court to dispense with mediation. But the idea that you'd have to do this after the fact, and as opposed to before you have to go to mediation, contributes, we found, to the delays in the justice system. Because this is an application that will now be in the court system, delaying the hearing of other applications, delaying trial dates, and of course, using the finite resources of the court that could have been used to deal with other matters if mediation was not mandatory. So that is what we found when we compared the United Kingdom's approach to mediation with our own. And the manual also considers, and this is the manual in the UK, considers the role of judicial encouragement, which is worthy of explaining and repeating in full. It says, while members of the judiciary have complete discretion on what to do in a case, research shows that mediation works best when there is some form of judicial encouragement, and that such encouragement can be quite robust. But referral is a delicate balance. On the one hand, a push for or gentle encouragement from the judge could possibly be viewed as a relief where the parties might not want to suggest mediation for fear of losing face. Even where there is strong judicial support for mediation, some parties will still wrongly interpret a proposal to try to mediate as a sign of weakness. But research also shows that if a judge is too forceful, it could lead to unwilling parties going to mediation. Similarly, if a judge is over-enthusiastic about mediation, unsuitable cases could be referred to mediation, which might be unlikely to settle, particularly where the mediation is time limited to 3 hours, end quote. So one of the things that we found interesting and very instructive from this quotation is that unwillingness of parties to go to mediation is more likely to result in some level of unsuccessfulness. On the reverse, parties themselves may view the question or request for mediation as an indication of their respective positions. So if I ask that we go to mediation, it could mean that I don't believe strongly in my position and it is better for me to settle. And so that may be a reason why parties would opt out of the mediation exercise and why a judge or automatic referral might be preferred. However, we have to tie it back into the reality of Jamaica, which is that mediation results in so few frequencies from compromises rather, result so infrequently from mediation exercises that this questions, the entire structure and efficiency of this automatic referral. Perhaps, and which is one of our recommendations, parties should opt from the beginning to go to mediation. Parties should not be mandatorily required to attend mediation and should not have to sit and go to mediation simply because it is part of the process when they do not have that willingness from the beginning to go and iron out those issues. So there is a concession that one size does not fit all. It does, however, indicate that mediation is most successful when the parties have agreed and willingly gone to mediation. So that I believe sums up for the most part what is a very detailed document explaining the rules, the structure of the rules, the purpose of mediation, and whether or not it has met those objectives and purpose in the way that mediation has been working or not working in Jamaica. So finally, we would close by indicating the most, I think, the strongest perspective in relation to mediation or legislative framework, which is our constitution. So under the Jamaican constitution, there are certain rights which are guaranteed. There is the right to equality before the law, for instance, right to equitable and humane treatment by any public authority in exercise of any functions, the right to freedom from discrimination on the ground of social class, for instance, and the right to due process as provided in section 16 of the Constitution. So, in particular, the question of the right to due process arose when we considered the bulwarks that we found with mediation as it is in our framework. So section 16 of the Constitution says, whenever a person is charged with a criminal offense, he shall be afforded a fair hearing within a reasonable time by an independent and impartial court established by law. And section 16.2 speaks to the same in relation to a person's civil rights and obligations or any legal process which may result in an adverse decision to his interests. That person is entitled to a fair hearing within a reasonable time. So our question and what is posed by this is, when we consider the delay that is meted out, the lack of efficiency with which mediation results in a tangible compromise, when we consider the $25,000 charge per party, do all of these things guarantee that there is the right to fair and equitable treatment, the right to a fair hearing within a reasonable time, when all of these things act in the way they do to prevent parties from accessing court within a reasonable time? So I'm deliberately ending here because that may potentially be a challenge which must be determined by the courts. But from where we stand, the low instances of success, the increased timelines for trial and trial dates, and the delays in the access to court, and the fact that there is a mandatory penalty, mandatory requirement for the $25,000 to be paid, that those things may impact on your right to access the court and may be a question about the constitutionality. And finally, as we said before, there is a question as to where the civil procedure rules get its jurisdiction to provide for automatic / mandatory / non-discretionary referral to mediation when the substantial and the primary legislation doesn't seem to empower the rule makers to make those provisions. So I think I've said a mouthful, and I know that the paper and the findings are far more substantial. But I believe that's a way to end this presentation, and unless there's any questions, but it looks like Roger has some questions.
Thank you so much, Mikhail. There is a query here online that says, what would you give to the notion of increasing the number of judges in the system?
Okay, that's actually a very good question, because in the paper itself, and I'll seem to find it, there are 61 pages, so forgive me for not going through everything with a fine-tooth comb, but there is a very interesting quote from the Privy Council which I wish to share. It was actually very recently referred to by Justice Sykes, as he then was before he became Chief Justice. It's the case of Bell against the Director of Public Prosecutions of Jamaica. It was a question in a criminal context, of course, as to whether or not what is a reasonable time for a fair hearing as required under the Constitution. As we said, Section 16.1 and Section 16.2 in the case of civil matters, the reasonable time for a fair hearing. What the Privy Council noted is, quote, "The courts of Jamaica must balance the fundamental right of the individual to a fair trial within a reasonable time against the public interest in the attainment of justice in the context of the prevailing system of legal administration and the prevailing economic, social, and cultural conditions to be found in Jamaica. The administration of justice in Jamaica is faced with a problem not unknown in other countries of disparity between the demand for legal services and the supply of legal services." And the Privy Council says delays are inevitable. When a more recent case, which is the case of Mervyn Cameron against the Attorney General of Jamaica, which is a 2018 case, Justice Sykes referred to, as he then was, he's now Chief Justice, but then he was Justice Sykes. Now in response to that, he says, and I quote, "This was the advice 31 years ago. The concerns are still with us today despite the doubling of the judges of the Supreme Court since Bell was decided, and the addition of many more courtrooms. The numbers of cases have simply exploded. For the last decade, at least, murders alone in Jamaica, and I'm adding in Jamaica, have been in excess of 800 per year. The government cannot increase the number of courtrooms and judges without limitation, because each courtroom and each judge carry support services which themselves have a cost. There is the recurrent cost of maintenance of the physical plant, the cost in terms of salaries for judges, and the cost of the support systems. The efficiency of the courts has to improve, and how we do that needs to be more cost effective." So that was what Justice Sykes, as he then was in 2008, had said in relation to that question about the increasing of the judges. But he also referred to the point made by the Privy Council themselves in the Bell case, where it went on to say that the solution is not necessarily to be found in the increase in the supply of legal services by the appointment of judges, the creation of new courts, and the qualification of additional lawyers. What the Privy Council warned was that an injudicious attempt to expand an existing system of courts, judges, and practitioners could lead to the deterioration in the quality of the justice administered and to the conviction of the innocent and the acquittal of the guilty. So, and that's the end of that quote from the Privy Council. So, on the one hand, we have seen an increase in judges, an increase in court spaces, courtrooms. And of course, we've also seen an increase in the number of attorneys which have come out of our respective law schools and qualified to practice in our jurisdiction. But that actually, based on the statistics from 2017 to 2019, doesn't necessarily indicate that we're dealing with the issue of longer waiting times from filing a claim to hearing it in the Supreme Court, and doesn't reduce the number of years that it takes for the disposal of matters. So my personal view is perhaps it's not so easy as just getting additional judges. It's not so easy as getting additional support staff for judges, and it's not as easy as saying we need more lawyers, because there, according to many, there's a glut. So I think the answer is that it's a delicate balance of everything that is required. But certainly as it regards mediation, I do believe there is a place for mediation to resolve these issues, but I don't believe that, based on the statistics, that there is sufficient evidence to show that the way that it is presented and the framework of it in our current dispensation assists with fixing those problems. In fact, the view is, based on all of this, it exacerbates the issues that are being found, being faced by us.
Another question is, how does ADR and other alternative justice options alleviate the issues of court backlog in the justice system?
Okay, my particular view on this is, I do believe, especially with older cases that may have been lost in the system or not getting the attention that are required, perhaps over 5 years or beyond the period of current disposal of matters on average, that mediation may be the better alternative to trying to revive them through the court systems. So in that respect, I think dealing specifically with backlogged civil cases of, say, 5 years or more through mediation is perhaps the best, one of the best ways of dealing with it. But insofar as new matters are concerned, my view is mediation should be pre-litigation requirements, perhaps, or once a claim is filed, it should not be an automatic situation. It should be a situation where the parties agree, and that willingness would translate to, my view, higher frequency of success and mediation. But as it currently stands, it is creating or adding to the backlog, since it is increasing or has contributed to the increase in the time of disposal of matters.
Yeah. Mikhail, you can probably help us to clarify. Online, there's this big discussion about $25,000 and what people can barely afford, and whether or not paying it is going to be throwing it away at this time. I think it's relating to mediation
fees.
Yes.
All right. So the way that it currently obtains, and the document goes a little more deeper into this. The Dispute Resolution Foundation, for instance, is according to its mission statement and its objectives and the information available through the Ministry of Justice's website, is a voluntary organization where the mediators volunteer their services to hear matters. What has happened, however, is that even though this is a voluntary matter, there is that mandatory requirement for the $25,000 to be paid per party to the mediation. And there is a recent gazette which says that half goes to the Dispute Resolution Foundation and half goes to the mediator. So in a $50,000 mediation session, 25 goes to the Dispute Resolution Foundation to build capacity, to get equipment, etc. And the other $25,000 goes to the mediator. Now, the immediate question is, what does that $25,000 have in the grand scheme of things? It means that, and we're looking specifically at indigent persons who are carried to court and not necessarily the indigent person who goes to court for some relief against a defendant. So consider the fact that I've taken Roger to court, and Roger is a man of straw, and Roger is not someone who anticipated that I would have carried him to court or budgeted for me to carry to court. That $25,000 that he would be required to pay, whether or not he has a lawyer, whether or not he can afford one, whether or not one is provided, that is a $25,000 cost that attaches to litigation. There have been media reports which indicate that the overall cost of litigation in Jamaica is very high. And you know, that $25,000 in the grand scheme of how much you may end up paying an attorney is maybe a drop in the bucket. However, nonetheless, it's not just about that dollar figure in a vacuum, because many people would perhaps be able to afford $25,000. It's that $25,000 where you are not guaranteed any success, where you are not guaranteed that you are willing to mediate and therefore have a mediation mindset open to compromise. It is not guaranteed that the other side, who might, and in this case, the example, I may be able to afford the $25,000 and much more because I'm a company, or because I am someone who owns a company in my individual capacity. So all of those things make the playing field unlevel, where I now can use this $25,000 if I know Roger can't afford it, to have an advantage over Roger in litigation. And especially if that $25,000 means more to that defendant who cannot afford it, who is more willing to mediate because this is $25,000 they had to struggle to obtain. That, I believe, is not something which is equitable. It is not something which is fair, and it certainly acts as a bulwark, a block for justice in that theoretical and practical sense to work. So it might seem small, but it's in a vacuum it might, but in the grand scheme of the individual, it might be considered something rather unfair. And ultimately, looking outside of, say, for instance, Roger and I as the litigant, in the court system, that $25,000, even though not passed on to the court, is not the only cost that is attributable to the entire mediation process. The cost to other litigants who have to wait in line for court dates, there's a cost to other litigants who have to wait in line for mediators, there's a cost to other litigants who have to set up time and dates with mediators in order to access the court. That also goes above and beyond that $25,000. But nonetheless, I take the point, it might seem small in the grand scheme of things, but in the grand scheme of things, there are things which relate to that $25,000, which makes it an impediment.
A question here says, can you elaborate on the term settlement week and how it relates to the ADR?
Okay, great. So the drafters of our civil procedure rules created a provision related to what we call settlement week, which is where the Chief Justice will announce, perhaps during the long vacation period, which is from July, end of July to September 15, because the court term begins again on the 16th of September. Perhaps during that period, there would be a focus on matters which are in the court system and appear to be susceptible to successful mediation. Those weeks would be designated for the courts, court users, the judges, masters in chambers, etc., and perhaps even mediators outside of the Supreme Court or the employment of the courts, who will come in and perhaps for the morning to evening, for the entire week, try to get the parties to settle as much of the matters that can be settled. And that's one way that the drafters of our civil procedure rules sought to encourage parties to mediate their matters. Unfortunately, we have done quite a number of checks. We have sought advice in relation to whether or not any settlement week has actually happened in Jamaica. And unfortunately, though those provisions are there, we were unable to find evidence of any settlement weeks being employed by the court system. So I think it would be a good initiative to employ. The provision is certainly there, and if the parties agree to go to these settlement discussions during that week, then certainly we think there would be a higher likelihood that matters are settled and that the parties can move on with their lives. But unfortunately, we haven't had any instance of that as far as we could find.
Another question. What happens if during the mediation process a matter concerning sexual assault or rape of a child arises? That is, one of the parties confess to being a perpetrator. Is the moderator obligated to report this?
All right, so that is the mediator. During the mediation, the question is, and I understand the question, because even with the judicial system in terms of attorney-client privilege, and even the age-old view that, you know, what you say to your pastor in confessional is confidential, and even if you confess a crime, there is a view that that is so sacrosanct between the pastor, or rather God, and the person who confesses, that it shouldn't be disclosed. And even so with the court system, I mean attorney-client situation, there is the view that that kind of confession or confession of a crime might be grounds or is grounds to breach the confidentiality provisions between yourself and your client. In mediation, unfortunately, there isn't much information as to whether or not there is any such code for mediators, and I suspect, though, it's a matter of ethical discretion. If there is a threat or if there is a confession to a crime that cannot be settled, because even in criminal jurisdictions, settlements are encouraged to where they can be settled, and where the crime is of such a nature that it can be, I don't want to say cured, but it can be remedied without the formal court system. That has also been employed in the court systems and in the jurisdiction of the criminal courts. So it's a very thin line. If it is a matter where all the parties involved, in the victim, the victim's family, the parent, everyone is able to come to some kind of compromise that is fair, then certainly I think the mediator has the discretion to first create that compromise, and if the need arises, to inform the relevant parties, which may be terms of the agreement, inform the party, the relevant authorities rather, meaning the court system or the judge or the case workers who are annexed to that kind of system, about the offense and about the compromise. But I certainly can't give a definitive answer. It's a touchy area, and I think, you know, there can't be a one-size-fits-all. People say that the law is black and white and blind. Actually, it's not. The law takes into consideration a multitude of things. It takes into consideration the views of the parties in a lot of cases. And so the mediator in those circumstances and the parties, once they consent to something, perhaps then it could be something that's employed. So I'm sorry if the answer isn't a yes or no one. It's a yes and no, and perhaps somewhere in the middle.
I'm sure they can appreciate that. some parts of this question may have already been answered, but maybe you could answer the part that is needed. Is the referral of cases by courts to mediation done, and if yes, is it done with the consent of the parties?
All right, the way that it is set up in the Supreme Court, as we said, in the claim form proceedings where there are substantial disputes as to fact, then there is no question about mediation. It's automatic. You must go, and if you cannot go, you must apply to the court and demonstrate why you cannot go. And the courts, because of the general thrust of the Supreme Court and the civil procedure rules, the thrust is to encourage you to go. So they will be critical of your reasons not wanting to attend mediation or to dispense with it, and may make orders for you to go nonetheless. So there is that regime where it's mandatory, and they're very strict in their application to encourage you to attend mediation. On the reverse, there are certain matters which are fixed day claim form matters, which do not have substantial issues or disputes as to fact. So in these cases, mediation is not automatic. However, the court still has the general duty to encourage the parties to mediate, and in that case, the court may ask the parties, do you think this is a matter where mediation might be helpful? And in those instances, quite honestly, I would say, especially from my own experience, that the parties are more willing to go when asked by the court to go to mediation. And when those matters are referred, it is more likely that they have the receptive mindset to come to some kind of compromise. However, outside of that, the parties don't necessarily consent, but in those instances, there is the potential where the mediation is at the discretion of the court and the discretion of the parties. Consent is given by the parties, and in those cases, I believe that the parties have the mindset at least to follow through and compromise with the mediation exercise. But generally, the answer is no. In the Supreme Court, there is no consent where it's automatic, and where it is non-automatic, there is the likelihood of consent. In the parish courts, which is the lower monetary level courts, if a claim is below $1 million Jamaican, it goes to the parish courts in terms of money. There also is, quite honestly, the request made by the parish court judge to ask the parties, do you think this matter would benefit from some mediation? And in fact, in those instances, mediation is not mandatory, but it is at the discretion of the court, and it is with the consent of the parties that the parish court will refer matters to mediation. We do not have much statistics as it relates to mediation in the parish courts, and perhaps it's because these matters are discretionary and not necessarily automatic, so there's not necessarily that framework for accounting for it. But certainly, in the lower jurisdiction, which is the jurisdiction of the parish court, consent all the way for mediation.
Right, there's certainly more questions, but the presenter, it's been going for a while, so we have to show compassion. But at least one last question. There's a commendation about the depth of your review, yes. But also they're asking if the UK, in your opinion, is the UK system a better system?
Well, my issue with that question is this. Even the Privy Council has illustrated that there are variables which distinguish jurisdictions. Jamaica has a particular socio-economic variable that the United Kingdom doesn't suffer from, and the reverse is true. So if we are to compare Jamaican apples to American apples, for instance, we would find two different conclusions in relation to them. So in that sense, what I would say is the United Kingdom's approach to mediation has certain benefits which we see for the UK, the United Kingdom's jurisprudence, we see that what exists in Jamaica has some issues in terms of how we have automatic referral to mediation. I'm not going to go out on a limb and say that the UK version is better, but it certainly indicates that there are provisions that the UK have which we could benefit from in the way that we, for instance, have the parties opt in to mediation across the board as opposed to making it mandatory, and ensuring that because they opt in, there is the position that they're more likely to view mediation with a willingness, and from not necessarily from a position of apathy or disregard, because parties have been forced to not only go to mediation but to also pay for it when it's unlikely, statistically at least, that there will be a settlement arising out of it. So perhaps, I'm a lawyer for a reason. It doesn't seem that I give a straightforward answer all the time. So for this question, what I will say is the UK has certain strengths which we could adopt, and even in the UK's own manual, it speaks about the fact that there is a subtlety in the UK system where the judges can't be too forceful and they can't be too soft with mediation. And that delicacy of forceful encouragement or robust encouragement or soft encouragement might dilute or affect the mind of the litigants. In Jamaica, what is the positive about the current dispensation is that the impressions which may be given about how about judges' encouragement to mediation, it eliminates that. So that perception doesn't exist, since everybody has to go to mediation, so long as you fall in the category where it's automatic. So plus and minuses on either side, but in terms of Jamaica, what I can say definitively is there ought to be substantial primary legislation which undertones the jurisdiction of mediation in Jamaica, and there ought to be, if not those kinds of statutes and primary legislation, consent is required every time.
Okay, thank you so very much, Mikhail Williams. Excellent presentation and just wonderful feedback from online. The community is alive and well. We'll take a break at this time, and we'll be back with a panel discussion. Of course, we'll see that panel mounted on the screen for people to see when we come back with them. So that's it for this segment. We'll be right back with you. Okay, welcome back to the final segment of the afternoon. You are at the closing ceremony of the UWI EU Alternative Justice Initiative. We've had a full day so far. We've spoken, we've looked at the overall overview of the project. We've also touched base with persons in the legal realm, looking at the legal framework. We've touched base with the actors within the different sphere, persons in the restorative justice field, persons who are also doing ADR. So you've gotten a full sense of what is happening in the space, and now we've come to another panel discussion looking at the effectiveness of alternative justice in addressing family and community level violence in the era of COVID-19. Certainly, COVID-19 is a topical issue. It's with all of us, and certainly it's fitting for the topic we're looking at. Our panelists is Dr. Zoe Simpson, correct?
Yes, Zoe.
Zoe Simpson, Executive Director of the Women's Foundation of Jamaica. Mr. Anthony Freckleton, Executive Director of Manchester Parish Development Council. We also have joining us online Dr. Pauline Russell Brown, Executive Director of the Jamaica Family Planning Association. Also, we have Ms. Nikisha Sewell, Executive Director of Women's Resource and Outreach Center Limited. Panelists, pleasant afternoon.
Good afternoon. Thank you.
And we've had some really good panels so far today. Well, we've only had one, but I'm guessing as well that this is going to be another good one. You know, just the energy so far. Even if you don't believe you're giving energy, you're giving something. I'm feeling it. So it's a very good thing. But let's begin with a little bit of an introduction and your own experience and your work with ADR, starting off with Zoe.
Thank you so much. My pleasure to be on this panel and to share a little bit about the work we've been doing at the Women's Center of Jamaica Foundation. We are across Ireland in 18 spaces, all 14 parishes, mind you, and we operate from 18 sites. We focus on the adolescent mothers and their babies that they take to the centers. The fathers who impregnate the girls also, they're part of the equation and the work that we do. We have primarily focused on education and counseling as two primary tools that will situate the girls to cope with matters of abuse and violence. So an educated adolescent mother is empowered to pull herself away from situations that tend towards a gender-based violence. And these relationships can be explosive, as you can imagine. This is a young girl, 14, 15 years old, who is not armed, is not equipped with the strategies to cope with her own personal development, let alone this newness that is happening to her. Yes. And sometimes you have the fathers who say, they deny paternity, and so it's just explosive. She has no support from her family. She has no support from the community. She has no support from church. She's experiencing a lot of loss. It's internally, it's a lot of turmoil. And sometimes, like at the centers, we hear the girls fussing and throwing chairs, and we're thinking, it's not that they are so bad and wicked and cruel, and it's the pent-up anger. It is a sense of loss and the discrimination and the exclusion, because she drops out of school, she loses her friends, she has lost her virginity, and she's left in this situation. And so, absolutely. So we say, focus on your education, focus on your personal development. Set some life goals for yourself. Where do you see yourself later on in life, and so on. So, not that you're going to be distracted from the reality of your circumstances, but we are saying project. Look down beyond this, beyond today, beyond this hurdle, and let's make some strategies. Let's put some measures in place that will pull you out and help you to get on with your life. So you don't have to fuss and fight and you know, be in a quarrel with somebody who has left you, kind of a thing. Yeah. Focus on self and building self and elevating self. so that you can cope with what your realities.
Thank you. Being the fact that we're online and for the most part distant, I hope you don't mind the familiarity of calling you Zoe and
Pretty
Anthony.
much. That's very nice.
Right? Excellent. I think it's far better conversation.
There you have it. There you go.
We sound like friends and people who
family.
are part of a concept together.
That's
yeah?
right.
So that's good. Anthony, your take on your whole experience, your interest and involvement with ADR.
Thank you very much, and thanks for having me. As someone who is responsible for 425 districts in the parish of Manchester in 9 development areas, and the fact that over the last 3 years, the root cause of major crimes in our parish has stemmed from domestic violence. So we have a situation where it's coming out of the homes. People cannot cope because just in the middle of in our case, problems with the bauxite industry, our main economic pillar in our parish. Then the effects of climate change to sink in, and then we're in the middle of implementing a 2030 plan for Manchester, and that the current reality of that plan reveal a lot of inequities in the system, from education to health, you name it, right across the board. So that is the context in which any intervention has to be so tailored to get the attention and the support of the people on the ground. And that is why I'm very grateful to the EU and the UWI Equal Rights for Justice program for supporting us in producing our booklet, I Have Rights booklet, which is I've just brought up enough to take it across the country. We're going to be working with all the parish development committees across the country, so that, and this is volume 1, so that I think at the bottom of it all, especially in Manchester, over 96% of the people residents of Manchester, over 200,000, have no idea what the constitutional rights are. True. Rights of the child, you name it. How can you have so many people existing in a space and don't know what the rules are exactly? And then how are you going to get them now? My task is to empower them to participate in governance, to let them understand that they have a right. They're not obligated. Nobody's obligated to anyone for certain rights. Healthcare, education. Just for example, this has been going on now for decades, where every year thousands of young people in South Manchester, through no fault of their own, have exited the school system, without even one subject, undereducated. Why? Because the fact that the parents cannot afford the transportation costs. So they go to school. If you have three children to go to school, one will go to, two will go today, and so forth and so on. So that is what you're churning out. And then now, you see, so when you mix, that is mixed up with the COVID situation here now. You're going to detect a certain level of hopelessness in our society. And that is what I'm trying to do now, to get them, at least get their attention in all the 425 districts, and then get it out. So that eventually, one of these booklets will be in every household. We have 46,000 households in Manchester. At least one of these will be in there to help to guide them in participating in the we call it democracy what we have here.
Dr. Pauline Russell Brown, your take on involvement in ADR. It will take a while to reach her. Let's try again. Dr. Brown?
Yes, I'm here.
Okay, excellent. Just getting your take now on your involvement with ADR.
Mr. Forbes, your sound is very grainy. Could you repeat the question for me, please?
Just want to get your own, as an introductory segment, just getting your own take on your involvement with ADR.
Okay. I represent the Jamaica Family Planning Association. I'm the CEO. And over the many years that we've been involved in sexual and reproductive health and rights issues, we have focused on the rights of women and men to determine when and how they have their children. One of the things we have noticed in the past few years is the increase in the number of women who report to us, and it's the reporting is not direct. We have to often drag it out of women that they have been abused in some way or other, whether physically, emotionally, or otherwise. And so we have with the in the past few months established a more comprehensive gender-based violence program, in which we will provide counseling and referral in a very strategic kind of way for those women who come to us with those issues. We are very excited about this because, especially now with COVID, the numbers have increased. Up to now, we have not kept a very comprehensive record of the number of cases we are seeing for gender-based violence, but now we can with the support from the European Union, and we will be in a better position to understand how and when and from where these women are coming. What we know, and similarly to what Dr. Simpson mentioned, is that we also we are seeing very young women as well as older women. And it seems to us that the younger women are even more vulnerable because there are financial implications as well. So that when we refer and when we refer women to, for example, shelters, we often have to think about what are the financial implications for them and their children. So this is a program that we are very excited about. It is a very recent expansion of our services. So it's hard for us to report on numbers at this stage. But in another 6 months, we'll be very happy to come back and report on that.
Good afternoon. Thank you so much for having me. Well, at the Women's Resource and Outreach Center, I would say that ADR is probably central to the work that we do. We're located on Beechwood Avenue, and for persons who are not familiar with Kingston, we are sort of located between two communities, between Trenchtown and Kencott, two what you would consider very volatile communities in Jamaica. And most of our clients come from those communities. And I will tell you that I don't think there's a week that passes where we don't have to do some sort of intervention or have some sort of conversation. In our communities, gender-based violence is at a very high level. And that's something that we deal with almost on a daily basis with the women who either work at ROC or women that we partner with in terms of training or women that we outreach to. So that's something that we face and we see all the time. We address this through counseling and really just by having a presence in the community. Our building at ROC is known as the safe place in the community. Excellent. If somebody is in trouble, they know can run to ROC. Somebody is going to be there to talk to you. Even if the counselor is not there, someone will be there to reach out to you and to assist you and to help you find the correct help that you really need to get out of your situation. Not only do we work with women, we work with children. We have an after-school program at ROC, and the main focus is to help kids from volatile communities have a safe space. So between the hours of 2 and 4:30, their parents know they are somewhere where they're not going to be harmed. Because child abuse is also very rampant in our communities, and we want the children in those communities to know that there is somewhere where they will be cared for, where their parents do not have to worry. So by the time the parent gets home, the child will be home as well. We often say that the hours between 1 and 5 o'clock are the most dangerous times for children because they are left unattended at home. And many neighbors know this, predators know this, so we try to find a space where children are safe. We also reach out to adolescents. We have training and education programs. We have found that if you intervene early, you can stop young men from joining gangs. You need to show them what the alternatives are. So through our education programs, we ensure that they know that there is an option. Every single program at ROC has a counseling component or a psychosocial component. Excellent. We often say that the psychologist is probably the most important member of our team because very few people come to ROC and do not need counseling. Even among our staff, we provide counseling so that they can handle the stress that comes at them. Because we found that so many Jamaicans are in distress, and without counseling, without mediation, they're not able to function in life. We also address the elderly, which is a group that is often neglected. So our focus is that every Tuesday, if you come to Rock, there is a hot meal provided, and there is an opportunity for elderly persons to socialize, and also for them to come and share with us, because you probably would be surprised the number of human rights abuses that are meted out against elderly persons. So we try to meet them, and we try to help them many times intervene in their family situations. People try to throw them out of their house. They can't get access to health care. We try to address their most basic needs when they come to the Women's Resource and Outreach Center, because we found that our communities really need that support. They really need somewhere to go where they're going to find peace, and where also they're going to be chartered to the right channel. Because one of the things that I think Jamaicans really suffer with is access to information. Because they don't know, when I'm in trouble, when something goes wrong, when I'm facing violence, where do I go? And if more Jamaicans could have access just to who should I call, you'll be surprised how many things we'll be able to fix. At Rock, ADR is a major part of the work that we do, and projects like this really help us to really meet the needs of the most vulnerable Jamaicans. So we're very happy to have partnered with the ARJ project.
So how has COVID-19 impacted it, even working with children?
Oh, it's been very difficult for us because most of our children cannot come out. We actually had an activity for them last week where we showed them the videos from the Ministry of Justice, and they were able to talk about bullying and talk about, sexual abuse. And let me tell you, when the program ended, they didn't want to go home because they've been at home so long. They're not interacting with other persons, and we are very worried about children at home at this point, because the longer children stay at home, the longer the predators have to get to them. We are very concerned about children, and many of the children are at home unattended because their parents must go to work. And for those who would normally go to their grandparents in the summer, many of them are not at the grandparents. They're at home in homes by themselves. So at Rock, we're very concerned about the safety of the children at this time.
I think maybe many persons who were expert in the field or who were actors in the field, I think they knew. But for so many of us, we didn't know how much of a respite school and aftercare programs are for children who are suffering abuse. Nobody would have factored that school would have been a respite, would have been an escape, would have been a place of relief, right?
Safety.
A safety, and that is not just coming from, that is not just, that scenario is not just related to children, it's even to adolescents and adults.
Absolutely. If I may jump in?
Yes.
At the Women's Center, what we find is that the girls look forward to going to the centers. It creates a distance between the problem at home, the reality surrounding this early pregnancy, and hope.
Yes.
So no, during COVID, when we had to close the centers, we were mindful to maintain the contact. They couldn't come physically, but we took ourselves to them to again just create the distance and give them something else to preoccupy themselves with than looking at the circumstances around, the gloom and doom and the anxiety. What's going to happen to me, to my child? Am I going to be able to take care of the needs of my child, and so on? So we were able, thankfully, with support, you talk about support, to provide and maintain that contact with them. And we found that they were delighted when they recognized that they still had access to the centers, to the counselors, to that support that is so fundamental, to their welfare and well-being.
Excellent. How has your organization's work in ADR, restorative justice, mediation, counseling, rights awareness, all those mentioned, how have those been impacted by the assistance from the UWI EU initiative? Who would want to take that first? So,
in our case, we the project was focused at the Port Antonio Center. That was in dire need of improved space. Yes. And we were so thankful, we still are. As a matter of fact, when I spoke to the chairman today and reminded her that I'm coming to this activity, she said, be careful to say many thanks. Because when she visited, they were like, and the minister too, Minister Grange, they were like, we must do something about the Port Antonio space. And thankfully, the project extended itself to us so that we were able to renovate the space that is now has positioned us to provide the girls who will be returning to the center soon with adequate space within which we can deliver the services, the academics, which is fundamental, the counseling services. And here is a space now that we can also now more readily invite the parents who are pretty much a part of the equation and the support that the girls will need to come within the confines of the protocols surrounding COVID and so on, and be at ease for us to have the conversations. Not only the parents of the adolescent mothers, but the parents of the adolescent fathers, who must now also recognize that we are in this thing together. And we are, instead of saying, pulling yourself away and say, oh, it's your girl and it's her baby and it's her problem. No, we together, this is part of the ADR. Yes, together as a community, we must huddle and reflect on how we are going to resolve this issue of our youngsters who are faced with this matter and this new life. And life doesn't end here. There's a lot of life beyond, but we must hold hands together. So we're thankful for the space, is the point I'm making, so we can continue and as a matter of fact, extend the services in a safe environment.
It's an excellent outcome. Yes. Yes, Anthony.
Yes, we are very grateful for the support of the EU and UWI Equal Rights and Justice Program, because for our 2030 plan to work and its ideals, converting Manchester in the parish to be a parish of choice, to live, work, raise families and do business, right? We can't leave anybody behind, no, right? And it is, and I've been across the parish meeting with our 9 development areas in their schoolrooms, you know, and everybody wants a copy of this book, right? So it is their passport out of their, in their mind, unequal space, right? Information is the key.
Yes.
And once they're armed with information and immersing themselves in our governance program, where they are going to be consulted, that their district for the first time will be consulted in the delivery of certain services. How does a road get fixed? How does a health center get you understand what I'm saying now? Hitherto, what we're doing now, it was left up just a couple of people in a room.
Excellent.
And everything. So all we believe that if you want to empower them with the rules of engagement as it relates to living in our society, and give them an opportunity to participate in governance in a meaningful way, and they see that happening, and they realize that their school doesn't have to look like that. You know what I'm saying now, etc. They don't need to be carrying water on their head any longer, because it's not a universal thing. You know what I'm saying now? People took it for granted and all. And once you get somebody's self-esteem up, you know, right, the sky is the limit, right? So, and then when this looming kind of giant in our society down there, where the domestic violence now contributes over 75% of the major crimes, domestic violence does that. We have to understand that it's going to come back to the community level, and we have started in earnest today. This is a list of the 425 communities, right? So we're going to set up a nice database, and whether the idea is wherever you live in Manchester, you're entitled to the same level of services, etc., right? And we want to really continue that, so that at each development area committee, we're going to set up these centers, restorative justice centers, partnering with the Lay Magistrate Association. So you don't have to, the problem is things happen, they don't know how to correct it, and the easiest thing to correct it is violence, yes, right? And then you're 40 minutes away from the town center. By the time you get there, it's all over, you know. So this, in our mind, and that's why we're so grateful for the support here now. So because we're now going to, it's going to snowball all along, you know, and not only in Manchester, but in the 13 other PDCs across across the country, we want to work closer together so that at the end of the day, whether you live in wherever you live in this country, right, you can associate with one another, share ideas with one another, and it doesn't have to be this difficult.
Beautiful. I'm just loving it, Anthony. This whole concept of a ground-up approach, I think, is always the best option for sustained behavioral change. You know, I just wish you so much success with that sort of a concept. It's novel. It makes sense, and you know, and I hope you get the buy-in for it. Pauline. Hello. That's excellent.
You face to face.
That's fine. We still feel your energy from here. Are you hearing me clearly?
Repeat the question for me again, please.
So we were trying to find out in terms of whichever of this service you provide, whether it's ADR, restorative justice, mediation, counseling, rights awareness, whichever of those you provide, how would it have been impacted by the assistance from the EU initiative?
Okay. All right. I should mention we provide services at 2 locations. One is downtown Kingston, and the other is in a more rural community in St. Anne. And what we find is that when the nurse, who was the person who would pick up the issue around whether gender-based violence or any kind of violence, she would refer out. And one of the things we observed was that many people would not go to the referred service for a number of reasons. One of which, they have established a relationship with the association, they trust us, and they would have to get to know this new organization all over again. So many of the people who she was referring out wouldn't go. So what this support is helping us to do is to expand our counseling program. We have hired a part-time counselor, and that person will be based at the location downtown. With the support from the project, from the UE Justice Project, we've been able to refurbish a space which will accommodate the counselor and a really attractive waiting area for clients whom the nurse will refer to the counselor. In addition to that, we will be offering telecounseling because, especially now with COVID, some of our interactions need to be by telephone. And so the project is going to help us to do the face-to-face as well as the virtual counseling efforts. We also will have some support for material and for engaging with media, because we see the media as very important in the whole business of violence prevention. And so we are going to be developing some tools which we can use with the media. And the support we are getting through the UE Justice Project will help us to do just that.
Thank you so very much. Nikisha?
You'd be remiss of me not to say thank you, really thank you to the ERJ project, because at ROC we were able to renovate some of our most widely used spaces. So one of the areas we got to fix up was our kitchen. As I said to you, every Tuesday we provide a hot meal for senior citizens there. And last week when the EU ambassador visited ROC, the person who cooks, she got up and she said, it feels like home when I go in that kitchen now. We're able to really give it a brand new fresh coat of paint, update the cabinets, so that the seniors have somewhere that they know is there, somewhere they feel comfortable when they have to come and cook their 30 and 40 pounds of rice on a Tuesday morning. We were also able to give a total overhaul to the multipurpose room. That room is where we have our after school program for the most part, and the children are just excited about that space. We're able to put down very nice mats there so they can actually sit on the floors. We're able to get new yoga mats because we use yoga as part of how we deal with stress, how we help the children to deal with all of the challenges they're going through. So we're able to renovate that space and also to provide a section where persons can come and do a resume, because we know that without employment we can't address any of the other challenges. So we put a computer in that room and a desk in that room, so when community members come in, they're able to have a designated space where they can access the internet, do their resume, and do the work they need to get done. We also are able to do over our counseling room, because as I said, counseling and mediation are critical for us. And we do counseling with individuals as well as families, as well as sexual and reproductive health counseling, which we'll be doing with the National Family Planning Board very soon. So we're able to give that section, the back section of our building, a real, overhaul, and it's looking beautiful. And the community members have told me that this makes them feel even more motivated to come out, because you want to have a space where persons feel welcome. And when you're dealing with very intimate issues and private issues, you want them to really feel that they can be calm, feel that they can come and they can share. And if you're in a room with just old black walls, maybe you won't feel as open. So we wanted that space to be very calm and welcoming. And through this project, we've been able to do that. And we are so grateful for that support.
It hasn't really been stated outright, but implicit in the discourse is this idea that the movements that all four panelists are a part of, that funding is as a challenge. How much of a challenge is funding for you? Because I think it's an important thing for people to understand, maybe for some more than others. But how important is funding, and how much of a challenge is funding for you in your different initiatives?
For us, funding is critical. Put it that we must have the funds with which to meet the needs of the girls. So it's not just even the basic things like staff and the general things and so like electricity and all of that. But it's caring for it's attending to the welfare needs of the girls.
Excellent.
It's a girl and her baby. Mm-hmm. In a number of instances, these girls have very little support.
Yes.
So she's going to have her baby next week.
Yeah.
And she doesn't have what to take to the hospital. She doesn't have the items for the baby, let alone herself, kind of a thing. So whereas we get funding for salaries and all of those things, we must secure additional funds to attend to the welfare needs of the girls. And then she exits the program of intervention at the Women's Center. She goes back to school, because that's the mandate. But she's now at second time dropout risk, unless she gets additional financial support and psychosocial support. And so we have initiated a program called the A-Stream program, assisting adolescent mothers to advance their secondary and tertiary and remedial education. Mm-hmm. And so we seek funding for that to ensure that when the girls are reintegrated, they remain in school and complete their secondary education. So they get a bursary to take care of school expenses, and we pay directly to the schools for fees and books and uniforms and exam fees, kind of a thing. Mm-hmm. And we monitor her progress. She's given a mentor to walk beside her, to support her, to say, yes, I did it, you can do it too, see me here now, kind of a thing, see you there tomorrow. Mm-hmm. And we walk beside them to ensure that they complete. And when she has completed, if it is that she is ambitious enough and wants to go to UWI,
it's okay.
Then we say we will walk beside you a little further.
I like that.
Oh yes. And so we assist her, not everything now, because we don't want our girls to think that this is a handout and life is about handouts. No, you are empowered to help yourself, but you need a little support. So we will assist you a little bit with tuition fees, which we pay directly to school, to the college, and we give her a mentor to walk beside her too. We're talking about education as a pivotal tool to help these women to get up and to get out and to get on, to be empowered. And so education is a powerful tool that the girls must have. Our woman, and an empowered, educated woman. It's a guarantee. We talk about Vision 2030 Jamaica. This is it, even, where we educate our young mothers who will now educate their sons and their daughters and break the cycle of poverty and gender-based violence, and so we can have a better Jamaica.
So you said it, and we can't say it enough.
That's right.
But well said. Anthony, what about you in terms of your own perspective? Do you have a perspective on particular funding, etc., etc.? I throw that to you. If you don't have any comment, fine, but I would love to hear from you.
Yes, you see, we have our work is based on our 2030 plan. Everything, every aspect of life is captured in that 2030 plan. The municipal corporation provides us with some support. Also the Ministry of Local Government. But we work closely with 9 development area committees that the parish is divided into. And it costs, transportation costs. That's one of the recurrent expenses that we're trying to eliminate now. But we have, it cannot be avoided. So what we're trying to do now is use technology more than before. That's why getting all these districts here signed up, and represented at the table will enable us to identify more of the needs. And then now, we also chair the interagency committee of the parish, so that will help to get things done. So we exist for the benefit of the people of Manchester, and by collaborating with various stakeholders, including the Environmental Foundation of Jamaica. They have been very supportive of the Tourism Enhancement Fund, etc. We helped out. We're now working with 20 schools to help them achieve the standard for water harvesting and storage, and so on. So we don't look and see there's a call for proposals and say, all right, let us do that. It has to tie in to what our objectives are. So we run a very tight ship, and our members help as it can't be done strictly from the resources that we get. We have to contribute. We are volunteers, and we have to make sure that at the end of the day we have something to show for it. For example,
Pauline.
If we're talking about challenges, I think we have to look at it at 2 levels. The challenge for the person who comes in for the counseling, and the challenge for us as an agency and organization in addressing those challenges. And I'll deal with the challenge from the organizational point of view first. We are very mindful that sometimes when you offer counseling and guidance to one person in the partnership, the other person gets suspicious and there could be retaliation. So we have to tread very carefully in that regard. And I'm sure that others on the panel would agree with me, and they have maybe firsthand experience with that. So we are very mindful, and we really want in the future to think about expanding the program to include the other partner and counseling for the other partner, so that we overcome some of the challenges at the organizational level, which in fact impact the challenges for the person. And I notice I'm saying person because we do expect that some men will come in victims of gender-based violence, maybe not in the same proportions as the women, but in fact they sometimes are victims. And so we want to reduce the challenges for them by providing in the future. Right now we can't do it, unfortunately, but some education, some counseling for the other partner. And so the challenge for the individual is how do I get this care and this service? I have to go back home into the same circumstance, because we in Jamaica have very few facilities that will provide accommodation for women, and I say women in this case, and their children who have been victims of violence. And so that's an area I think that we need to advocate. Those of us who are part of this project need to get together and advocate for in the future, so that in fact we increase the number of facilities from, I believe we now have 2, or is it 1? In Kingston, maybe 1 on the other end of the island, to increase the facilities for women, whether it is in somebody's home, whether it is in a and a civil society run organization facility. But that is a major challenge, I believe, for us in this business. Where does a woman go when she's faced with so much violence that is overwhelming, and just the counseling and the guidance is insufficient? She needs to get out of the situation to a safe place and get out quickly. We've seen examples in the past few years of women who have attempted to leave a situation, and because they didn't leave quickly enough, they are no more. They're not here to tell us the story. And so, that's an area I think we really need to advocate for. Even as we counsel women and educate them, we need to also provide the spaces where they can go to be safe if they decide to leave the partnership. So those are the challenges that we at the association have identified, and we'll work with other partners to address some of these challenges.
Nikisha?
In terms of challenges, you had asked earlier about funding.
Yes.
Major challenge. There is not a day that funding is not a challenge for ROC, because we are primarily funded by international grants and private funds. So we do not receive funds from the government, hardly ever. So it's a very challenging topic. It's a very, especially in COVID times, very difficult for us, because we try to provide the best support we can for our community, but they all come with needs.
Yes.
And we have needs. First of all, we need to keep the light on. So those core, first we try to address the issue of core funding, which most projects now do not cover, which is something many people may not be aware of, that many international grants or even private grants, they don't cover your core bills. So they don't cover your core staff. So our core staff tends to be very worked to the bone, because they not only have to work on the institutional side, they have to work on the project side as well. And then when you provide for a community, you sometimes end up trying to really scale back, because you're thinking, I have to provide everything. Because when a mother comes with a challenge, she's bringing her children, and it usually ends up being an intergenerational challenge. So her mother may end up coming, or other members of the family. And so when you try to help, it keeps spiraling, and it's hard to just, and I can't, even for instance, I can't provide training to somebody if I'm not going to help them to find a job in the end, and I have to provide a meal at every training, and every training we also have to provide childcare, because we at ROC, we know we do not accept women coming to training and leaving their children at home. So the training bill that probably was 5,000 ends up being 15,000 per person, because you just have to provide all these other steps so that persons can access the support they need. So funding, my constant headache, but it's a challenge that we are just trying to fight through, especially in COVID times when money is really needed in so many areas.
Which is why it's important for you to identify it, and for our listeners and viewers to hear and to make note of. From your perspective, what are some of the ADR practices that have not worked well in the communities that you serve? Please explain why you believe these practices have not worked as well as expected. Who will take on that one? Let me read that again. From your perspective, what are some of the ADR practices that have not worked well in the communities that you serve? Please explain why you believe these practices have not worked as well as expected. Is this applicable to all? And to whom it is applicable, please respond.
Well, I'll go ahead. I think for us, based on our experience, anything that is a top-down model is very difficult, because you're working, everybody has a strategy and they have a plan and a 15-page action plan, but you're dealing with individuals. If your model does not include talking to the persons who are affected, especially as it relates to violence, I would tell you just throw it out. And you can't deal with, we don't deal with challenges in isolation. So as Dr. Brown had said earlier, when you're dealing with a mother, you are dealing with her partner and her children. And so we find that where there is gender-based violence, there's sometimes you have child abuse as well as other forms of domestic violence in the home. So while the project may be, let's address just gender-based violence, you can't just do that, because you can't take a woman or a partner out of just that situation. What about the other challenges that the person is facing? And yes, I've helped you to deal with gender-based violence, but you still have no money. So therefore you have to go back home to the same man who is abusing you. So when the projects when the strategies are very, I would say, narrow-minded, or very, you're looking at a hot topic, and not looking at the overall life experience of the persons that you're dealing with, it is very, very, very challenging. And another area that I have constantly advocated, and I really think, I'm hoping we're going to get better, is how communities interface with police. It's been a major challenge for us. There are some wonderful police officers out there, and then there are those who have made my job very difficult, because I think there is this perception that gender-based violence has become a part of life, so it's normal. And I have many clients who, when they go to report violence, they're brushed off. Nothing comes from it. And then what happens? Violence escalates. Violence ends up being part of the children's lives as well. And even deaths that you have seen as a result of gender-based violence, part of it is that when they first report, that first report is not taken seriously. That first report is not addressed. And so for me, the police continue to be something that I am working on, and I'm actually praying about too in Jamaica, that we really get to that point where persons can make a report and they are given real support. And a major challenge I have had, and I've talked about this, is when you work with groups such as Sisuka who do wonderful work, it is sometimes challenging for community people, because if I live in Trenchard and I go to report a crime, if once it's a sexual or abuse-based crime, they send you to the Sisuka office. If I don't have bus fare, you can forget about that. And then when I report that crime, if I have to take out a restraining order, that is a different police station that I have to go to. So if I don't have bus fare to take you from Sisuka to the Half-Tree police station, that is another level. So the victims, they are re-victimized over and over. And every time they go to a police station, they have to tell the story over and over again. And so if we could find a way where everything is centralized, and I know they're trying with the restorative justice centers, I think we would see a lot more work being done on gender-based violence and child abuse in particular, because to have to drive a person from Trenchtown police station to Sisuka and then to the Half-Tree police station, and then you almost feel as if you have to self-monitor, because if the man is coming after me, I have to call the police to let them know he's outside. I think it is too many steps for victims, particularly as it relates to gender-based violence. If there's too much work. In the case of, just take for example, when someone is murdered, the state takes on that crime as its own crime. In the case of abuse, it is my responsibility as the victim to seek my own justice. That, for me, is something I would love to see Jamaica change, where victims are really supported through the process. Because right now, it is very hard for me to convince somebody that she should go and report a crime on somebody. The person, first of all, he is providing food for her. So when she reports on him, where is she going to live? Who is going to provide for her? What happens to her children? And remember that when she reports on him, that does not stop his parental rights. And many times they will use that kind of argument, I'm here to see my children, as an avenue to come back into the home. So in terms of support for victims, real support where they're not being dragged around the justice system, where they're able to have one access point where they can access everything they need. For me, if we could fix that, we would be able to really save so many more lives.
Excellent. Is there anyone else who have a contribution on this? Pauline?
Fanny, yes. One of the lessons we learned from family planning work in the past is that if you don't engage the other partner in the discussion, or at least inform the other partner of how these methods work, you're not going to get anywhere. What we found, and not just in Jamaica, but globally, women were being abused if they decided to choose a contraceptive method. And when we did the research, what we found was that the men didn't understand how these methods worked, and they thought in many cases that the method would be harmful to their partner. And what we found is that once we began to educate men and they got an understanding of how the methods worked, then they were more willing to they understood why they need to plan their pregnancies, and that these methods, in fact, could be used by their women without harming them. So I'm saying that to suggest that maybe in our work on violence, we need to do more to engage with the other person as well, and to educate and inform and do the things that will help to change behaviors. And some of these things are almost systemic. They're related to financial matters. They're relating to gender relations. It's not. I'm not trying to make it sound as if it's going to be easy to achieve, but I believe if we place as much emphasis on the other partner, the perpetrator, as we do on the victim, we may see some progress in this area.
And the sharing is really powerful. I have just one last question. It requires a little unpacking. I have one last question and it requires a little unpacking. So I'm going to ask you to bear with me. Based on the communities that you serve, what are some of the best practices that you would recommend for treating with child abuse, intimate partner violence, family violence, and community violence? That is, based on the communities that you serve, what are some of the best practices that you would recommend for treating with child abuse, intimate partner violence, family violence, and community violence?
Wow. Nobody wants to say anything on this one.
We have learned at Rock. One of the things that we did that worked excellently was that we used to do these pop-up clinics, and we're hoping to do them in the future. So when there's a health fair.
Hold on, Nikisha, because interestingly, based on what Rock is doing, you would cover quite a range of these, wouldn't you?
Right about them.
Okay, all right. So just checking.
Yeah, so
Good.
our pop-up clinics, what we did is that we had our psychologists go into the community. So when they had like an SDC fair, you had a counseling. We would do like a pop-up counseling. And we got persons to come in and talk to them for only 30 minutes. Because many community people are afraid to talk to a psychologist, they're afraid to talk to a counselor. But when you bring them to an event where you have the NIS and the National Health Fund, they will be there and then we would just go out and say, you know, we have somebody who can talk to you, you're having a problem. Let's talk to this lady, it's only 30 minutes. So we made the sessions only 30 minutes long. And let me tell you, after we did those sessions, people would come into the center more.
Whoa.
But you have to go where they are. Us staying at Rock, inviting them, they're never, especially with men, they are never coming into the center. But we go to places where they are, and we found that that really works. Another intervention we did, we went out and we gave out condoms in the communities, and it gave us an opportunity to talk to men about a range of issues. Talk to them about domestic violence, talk to them about parenting. And when we went to the bars and went to the corners where they were, it was much easier, because getting men into Rock, you can just imagine how difficult that is. So that really works for us. As I said, our after-school program where we provide a safe space for children, really great best practice. And then it also provides us an opportunity to meet the parents, because parenting is probably one of the most harmful, I would say bad parenting is probably one of the most harmful things to Jamaican children. At Rock, if your child comes there, it gives us the opportunity to meet with you, to counsel you. So when you bring your children to Rock, we invite you to come and meet the psychologist. And if something happens, we call the parents and we maintain a relationship with them. And I think getting outside of the building is probably the best thing we do, because you can have a beautiful building inside, but if nobody's coming in, if the people don't trust you and know you, people in our community, they know the people who work at Rock. They go out and they really interact with people, and they meet them at their whatever level they're at. And we partner with community persons, that we develop groups with persons within the community. So we have what is called a women empowerment group, and that's a grouping of women from the community who they go out and do the advocacy for us. So it's not just the ones who are Rock staff members, but we have a group of community members where when there's an issue of domestic violence, when there's an issue of child abuse, they go to the homes, they talk to the mothers, and these are women that the community knows them. So the community knows who they are, they trust them. And so if I were to say to a parent, boy, you need to go to Sissoko, maybe they wouldn't listen to me. But Opal, who is the head of the Women's Empowerment Group, having lived in Trenchtown for over 20 years, if she goes and talks to a mother, the mother feels much more comfortable speaking to her, because she knows her, she grew up with her, and so she feels she can share with her. So they go in and they do the intervention on our behalf. Yes. And then they bring them to Rock. So really getting out into the community. And for me, maybe the best practice is really, as my Sunday school teacher would say, using the 2 ears 2 times as much as you use your mouth. Letting community people talk for themselves has probably brought us the most results. When they feel they have a space where they can speak and they're not going to be judged, and whatever they say to you whatever they say to you is, in some cases confidential, but they know their voice is being heard. They feel much more comfortable sharing their stories. Most of what we probably garner from the community is when we take time out of our day to just go and sit and talk to them, just sit in a bar, sit in a local corner shop. And trust me, you hear all kind of things in the corner shop that you would not hear when they're coming into a formal counseling environment. Go to their football matches, get to know the teachers, really go out there. That is where we can really make a difference as it relates to crime and violence. People must know that they can trust you and that you are working in their best interest at all times. Then you really can address the challenges, because once you develop a layer of trust, you can start to change. And then I would say, work with men. We have this idea that because, and in many cases, men are the perpetrators of violence, many of Jamaica's men and young boys, they are broken and they really need support. I can tell you some of the most remarkable stories we have at Rock are about young men who we meet them at probably at age 8 and they go off to go to university because we started the intervention very early.
Oh.
But you have to work with men. You can no longer see them as just the perpetrators, but they must be part and they must be critical to the work that you do. You cannot change Jamaica without intervening in the lives of young men.
Wow.
To follow up on some of the best practices that ROC is doing, in a similar way at the Women's Center, I did say that we work with the young men also, young fathers in particular. And what we have found is, since we are called Women's Center, there's a little challenge with the young men coming to us, kind of a thing. So we've worked around that, mind you, by holding hands with powerful young men in the communities. And again, we take the young men, the counseling, the work we do with the young men outside of the Women's Center into spaces in the communities that are facilitated by men, so they can have the man-to-man talk.
Yes.
It's not another woman coming to tell me what she don't even understand herself about men. So they talk men to men, and we are partnering with the Bureau of Gender Affairs, the male desk, for the male face to be the one to interface with the young fathers, so they can talk about the male issues and the male sexuality issues, and the treating with the woman issues, and self-development as a man issues, those kind of things. So that's pretty much what we have done too, and counsel with the young men, so that they can think of something else. You don't have to be violent. We can reason this out, as an alternative kind of a thing. Where the girls are concerned, alternately, we have sought to take them out of the communities too. Because sometimes we find that they think that this is life and living. It's confined to what obtains in my community. No, man, we take them up somewhere else.
Excellent.
We take them into spaces where you have other women so they can see role models and recognize that there's something else. We help our young women to reach inside of themselves and identify what's inside of you that maybe nobody else has ever helped you to understand, that you're bright and beautiful and there's so much more inside. So for example, at the Port Antonio Center where this project is located, we've called this space the Harmony Hub, where we say to the young ladies, take time out and just introspect and dig deep and see and understand who you are, and understand that you have it as a woman inside of you.
Self-discovery.
Thank you so much.
Powerful.
Absolutely. And so you are able to now critically think through your issues and find solutions even. I want to go back to the young men though, because I think I want to mention the fact of, instead of us as a nation criminalizing our young men, I'm talking about the adolescent fathers in particular here, and we have those, right? The child diversion program, which the Women's Center is a pivotal part of, we seek to counsel with these young men who, just like the girls the adolescent hormones kicking and, they hot and everything and so on. The young men also need to be helped to understand their sexuality. And in the community, they are told that you prove your manhood by... And we're saying, there's another way. Let's look at this differently, kind of a thing, and so on. So if it happened, though, the child diversion, so they come to us for the counseling. And again, we're working with the male desk to help to deliver and to help the young men to understand male sexuality. We think that is a topic for women to talk about. No, the men. I am happy that you're looking at it like that at Rock too. They need somebody. We need to help our young men as a country to reposition, to rethink, to aspire towards other things than just having sex all over the place.
Excellent. Anthony?
I'm just marveling to see where I'm in Manchester. Everything is multiplied so many times, and when I get into Kingston, it's like another country, basically. Yeah. So I have to just admire the work of these two ladies here, because I know, it is not an easy thing. You know what I mean? But you have the infrastructure here, the breeding ground. You know what I'm saying? Yeah. For all of that. So I'll just pass on that.
Yeah. And I think based even on your model too, this whole idea of the top-down approach may also help in terms of community violence as well. The level of empowerment and education and the knowledge that you will feed to people will affect behavior. That will also feed into overall behavioral change, and also how people at that level deal with each other and deal with violence in their spaces. So I think you're onto something also very powerful. Thank you though. Pauline, we're not hearing your volume. You may be on mute.
No, I'm not.
Okay, we're hearing you now.
Are you hearing me now? Yes? Coming back to best practices, it is very evident, just listening to the presentation so far, that what works for females won't necessarily work for males. Okay? And so that is something I think we have to be mindful of in all our social interventions. For a number of reasons, boys and girls respond differently to the same stimuli. They learn differently. And so we have to be mindful that we have to try different interventions with males as opposed to females. The other issue is, and this applies to both genders, all genders, is that we are in a culture where everybody has to win. So we're having an argument, we're having a conversation, and I have to come out winning. If I don't win, I'm going to hurt you. So how can we, and I think the best interventions are those which allow a win-win situation for everybody. And those interventions are possible in communication as well as in other areas. So the person who is having, the people who are having the conversations, none of them feels that they have lost this argument, because that's a diss, right? And you know how we respond when we are dissed. Okay, so for me, the best interventions are those where, in fact, we enable people to come out, feel like they are winning, whichever side of the conversation, whichever side of the debate they are on. Okay?
Okay. Zoe, Anthony, Pauline, Nikisha, thank you so very much for joining us and for sharing in the ways you have. I know the audience have appreciated it, because certainly listening on and just learning and just taking in all of the breadth of work that you're doing, whether it's in the communities, whether it's with women, whether it's with families and children, whether it's just amazing. And you're doing this scope of work in an environment with so much restrictions given because of the pandemic, but also added to the stress because of issues of funding and other areas. And you in the process also having to do a lot of awareness building and that sort of a thing. It speaks to a breadth of work. And 24 months ago, when the UNI and the EU started this initiative, who would have known, would have delved so deeply to be able to bring so much to share with you. But that is the end of the sharing for today. We come back with more sharing tomorrow morning at 9 o'clock. So please join us. We would love to hear from you. We are going to be here. We're going to bring the same sort of energy we brought today. We're going to be sitting down with people, talking with them, hearing their concerns. And of course, we're going to be wanting to hear your concerns. That's why you can always send us your feedback online. Please do so. But until tomorrow morning, take good care, and thanks for joining us.